Good afternoon, members. I call Committee of a Whole on Bill 7, Economic Stabilization Tariff Response Act, to order. We are at Clause 8. Shall Clause 8 pass? Oh, yeah. MLA Prince George Mackenzie.
Thank you, Madam Chair, and welcome back, everyone, to Bill 7 debate. We've had a little bit of a break, but nice to see everyone again in smaller quarters today, but we'll make do. So we're on Clause 8 that deals with immunity. So we're still obviously on Part 2 of the bill. So I'm wondering, maybe just to start off the discussion on this, if the Attorney General can briefly describe why this section is actually included.
Attorney General.
Thank you. So welcome back. Yeah, welcome back, everybody. The reason for this provision specifically is because through the procurement directives, we're directing government policy towards GREs, so outside of government. So with that, and in discussion, as we were rolling out these procurement policies, it was felt important that there be some kind of immunity provided to these bodies that enact our government procurement policies, to make sure that if they are acting in compliance with the directive, it recognizes that it might conflict with other obligations of the organization or the individual, but that we would offer them a type of legal protection.
Member of Prince George Mackenzie.
Thank you, Madam Chair, and thank you for beginning the discussion there to the Attorney General. Just in sort of trying to ascertain the need for immunity overall, I'm wondering if the Attorney General could provide a scenario where this would be necessary. So an example or two that would actually help to describe for the public what this provision is trying to do.
Attorney General.
Thanks. So I guess the clearest example that I could provide is that, let's say that the organization that is now subject to a procurement directive has their own rules around procurement, duties, like mandate items that might actually conflict with it could also be legal duties, conflict with the procurement directive. And in that scenario, we want them to abide by the procurement directive, but if there's any legal issues that might arise from that, then we're also giving them protection from that. Is that okay?
Oh, Member Prince George Mackenzie?
Thank you, Madam Chair. So in that example used, would that apply in the case of a procurement directive being used on say a prime contract in a major project, if that was a procurement directive that was prescribed?
Attorney General?
So as an enabling piece of legislation, it enables the crafting of a directive to whatever that situation is, procurement directive. So in that assessment, you could take into account different versions of procurement, different how an entity operates in the world and what that would mean. So yeah, I mean, there's a potential for it to apply to a situation that the member is referring to, and then we also had I think a lengthy conversation about procurement. It might have been on clause 1, I don't remember, but it was about the viability and how there would be risk assessments, and it would be a matter of understanding what's viable and what's not.
Member Prince George Mackenzie?
Okay, thank you, Madam Chair, and thank you to the Attorney General for the acknowledgement. And I think that's part of the scenario I'm trying to understand. And I guess I worry about a situation where businesses may get into legal challenges over contracts subject to a procurement directive. And as I described probably in those discussions and maybe when we were way back in clause 1, I previously worked in construction, major project development, and with complex prime contractor relationships. And these are situations where government and crown corporations also enter into these massive prime contracts. They are, there are subcontracts that are fall under this. So many different types of businesses would fall under this prime contract. They're very important, but they're complex, and they're subject to significant litigation. In the case that I'm familiar with and what I worked in, there were multiple lawsuits, multiple situations where disputes between a prime contractor and project owner, and in this case, I'm trying to ascertain is the government is the owner or Crown Corporation is the owner. So the same thing where multiple disputes are occurring, I'm trying to understand where businesses will be impacted by immunity. So with that, I wonder if the minister can explain how these businesses that could be, included under procurement directives, under a prime contract or some sort of contract scenario, could seek remedies if they suffered damages due to government action, but immunity is applied under Section 8.1 here, so or Clause 8.1. So I just wonder if those businesses who may suffer damages, what's their recourse?
Attorney General.
Okay, so the first thing to remember in the kind of complicated environment that the member's talking about is that, there often are projects where there's multiple lawsuits related to contractual terms and prime contract, subcontract, and I understand with major projects that can be a big thing with many components to it. This is only around procurement. So any directive, so it narrows it quite a bit. So once you're already in that narrowed field, what we would say is that if an entity that we've given a procurement directive to abides by that procurement directive, and through that, whatever procurement process has had some liability occurred where a business is trying to seek damages, then the province would step in. So we would essentially immunize the entity for abiding by our procurement directive and take it on as a province. So that's the protection that we're offering them, and that's how it would show up. And that's under Clause 9.
Member Prince George Mackenzie.
Okay, thank you, Madam Chair. Okay, so if that's the immunity protection for those that are entering into contracts under the procurement directives, I guess, can maybe the Attorney General just describe how, why, I guess, this scenario why government would need that kind of level of, like, what, I'm trying to get at what the government is trying to achieve by using procurement directives in this way. Why not use existing tools, like why the existing legislation and why immunity in this case is actually needed, I guess.
Attorney General?
Thanks. So the whole purpose of this section is to do something quite unprecedented when it comes to directing procurement of all government entities in a certain way. And that is for the reasons that we talked about already, to unlock the ability of us to drive the economy through the money that we spend as a government and these government reporting entities in the community. And because of that, through this whole part, there is a consistency that is clear that we can make sure has like the legal mechanisms in place to make that clear and consistent throughout all government reporting entities, including the fact that because there are so many with different, and we talked about it before, like different mandates, different potentially existing policies, that we would provide the legal protections for them to fulfill that procurement directive. An example might be, let's say we're asking a government reporting entity to do a procurement by excluding American, and there is a lawsuit that comes into place that says, well, why are you wrongly excluding me from this procurement? And that government reporting entity has done what we've asked them to. Then we, as a government, we would say you're indemnified by that, and that would be our role to step in on that claim.
Member Prince George Mackenzie?
Thank you, Madam Chair, and thank you to the Attorney General for providing that example. I think it helped me to understand what the immunity looks like in this situation. But as we've talked about previously in the bill, it is broad sweeping. There is, in our estimation, we still think that there is overreach. So from asking these questions, it's trying to get really into the details of what that looks like in practice. Just maybe to finish up a little bit on the immunity side of things, I just want to maybe ask, were there any other mechanisms from a legal state that considered for some level of protection against legal proceedings? So immunity is not necessarily the only one. For example, was a reasonableness standard considered rather than full immunity, sort of to balance the government accountability and public protection in a different way, I guess?
Attorney General?
So there is a version of a reasonable standard built into the language of this, and just to say that you have to read section 8 and 9 together, but with respect to section 9 or section 8, you'll see that in the language that says against a protected person because of anything done or admitted in complying with or intending to comply with the directive issued under this, and then the subsection 2 does have a bad faith omission for that.
Member Prince George Mackenzie?
Thank you, Madam Chair, and thank you for the response to the Attorney General. Maybe I'll move to the bad faith component a little bit more in depth then. So what would be the test for determining bad faith for the purposes of this exception?
Attorney General.
Okay, thanks. So bad faith is a very well-used legal term that has a lot of case law to back it up. So essentially, what it would mean would be dishonesty, fraud, or some evidence of an ulterior motive that's inconsistent with the duties that that person should have been acting with.
Member Prince George Mackenzie.
Thank you, Madam Chair, and yeah, appreciate it's used in common law. And I don't come from a legal background, so appreciate knowing a little bit more about that. So would that be more of an objective or subjective kind of standard in common law practice then?
Attorney General.
That would be a subjective standard.
Can the minister provide a relevant example of what could be considered an exclusion due to bad faith in this case?
Attorney General.
Yeah, so there could be any number of examples that would meet a subjective standard, but I'll give you an example of what is kind of modeled off one of the big cases on this. So let's say you were, instead of following a procurement directive, you were, because of a personal issue with one of the businesses that wanted to bid, excluded them from that bidding, and it was related to that, and it was an ulterior kind of motive that you had that wasn't related to the duties that you had or the procurement directive and how that you should have been acting, then that would be an example of operating in bad faith.
Member Prince George Mackenzie.
Thank you, Madam Chair, and appreciate the example. So I guess in using that example would, and I'm still kind of in my mind working through those a procurement situation and a prime contract situation. Again, that's still where my head is at. But would there be some sort of an independent process for businesses or individuals to challenge government actions that they deem to be being made in bad faith?
Attorney General.
So if a business has some claim that they believe that alleges that the province acted inappropriately or in bad faith, then the courts are free for them to bring that claim forward. And we have a whole legal team in my ministry that responds to any number of claims, whether they're, we can test them and meet them in court with respect to that. But what this does is it doesn't actually it shifts the question of liability to the province instead of on the entity. It doesn't prevent, it doesn't bar anybody from challenging the province if they feel like they've been wronged for any number of ways.
Member Kelowna Mission.
Thank you, Madam Chair. Can the Attorney General expand a little bit on, given the subjectivity of the bad faith definition, I can imagine a number of scenarios in which the desire to achieve political objectives could easily blur with what could be defined as bad faith from a legal perspective. So could the Attorney General help us understand a little bit where those definitions would begin and end and how the risk of politicization would be mitigated in this context?
Attorney General.
Just to start off with situating where subsection 2 comes into play. So it is meant to cover a scenario where a government reporting entity, where we've issued a procurement directive to, acts in bad faith, and then the province is saying, well, we're not going to protect you if that's true. So it's removed from government. It's not a government thing. It would be something that the government reporting entity could do, and they wouldn't be protected from that. It's a fact-specific finding. So in the example the member raised, if a government reporting entity does do something that that looks like they made a decision on procurement that wasn't related to the directives, related to like political motives or whatever other reasons, then you could see that there could be a claim in bad faith, and then the court, it would be up to the court to decide whether that was made out by the facts. But the difference would be is that the province would say, in that scenario, we're not going to indemnify you for those actions.
Member from Kelowna Mission.
Thank you, Madam Chair. I appreciate the explanation. What I'm trying to get at and trying to understand is how this would function when there was a conflict between a policy or a political direction and the fiduciary obligation. So, for example, in hearing the Attorney General describe her prior example, it would not be a stretch of the imagination to picture a scenario where direction was given by government to take an approach to procurement, and a zealous individual at a GRE interpreted that direction in a way that became overtly political or became sufficiently political that government deemed it indefensible and chose to cut that individual loose because they had done something that, given the uncertainty around definitions, might have been in the political interests of the government, but not something explicitly mandated by government. So I'm trying to understand how this entire piece around bad faith and indemnification actually protects against politicization in procurement processes and strikes a balance in terms of protecting the fundamental interests of the taxpayers of British Columbia, as well as protecting the interests, for example, of whistleblowers, or protecting the interests of individuals who might, for example, believe they've been given a direction by government, follow that direction overzealously, and find themselves, becoming Oliver North.
Attorney General?
Thanks. So one of the clear benefits of having it in the legislation before a procurement directive is issued is it sets a standard of conduct for people that are, a GRE that might have a procurement directive issued at them. So I think the member is describing a scenario where it sounds like in that scenario, the entity would be, the procurement entity would be in breach of the directive, but also wouldn't have the benefit of the immunity provisions in this part, and so therefore would be liable directly for any breaches that they did in a way that was illegal.
Member Kelowna-Mission?
Thank you very much. Appreciate that explanation. So let's just take this a little bit further to a non-hypothetical. What I worry about is that in the course of debate on this bill, there's been an unwillingness to establish clarity around certain areas that could actually be very material here. So I want to lay out a non-hypothetical situation. Let's imagine, for the sake of argument, that a GRE that has responsibility for procurement and that has responsibility for doing so through a community benefits agreement or project labor agreement, as was previously flagged. Let's imagine that there is someone who is a procurement lead for a GRE and who has heard the direction from government that there is an effort to eliminate American content from procurement. Let's imagine that that individual working in a GRE believes they've heard that direction loud and clear, and let's imagine, for example, that they listened to previous debate on prior sections of this bill and didn't really get a clear answer. So let's imagine that having heard the political direction from this government, they arrive at the conclusion that it is in fact problematic that 19 of the labor unions participating in community benefits agreements are headquartered in the United States, and at least one, probably several of them, have donated to Donald Trump. So let's imagine, for the sake of argument, that they make a decision around changing the approach to procurement or arbitrarily making decisions within the procurement process, which, for example, they believe to be eliminating American content from procurement with British Columbia tax dollars. Now they find themselves in hot water, and they then turn around and find that there is this uncertainty as to whether or not they are protected, because the political direction issued by government, the policy direction issued by government, is insufficiently specific as to determine whether their actions are in fact compliant. And as we look to subsequent sections, there is obviously this piece, which we'll get to in the next section, around complying with or intending to comply with. So I'm really just trying to understand how we're not setting up situations in which we could have individuals acting in good faith, either individuals who simply believe they are following the direction of government, or individuals who happen to be aligned with the political direction of government, who take actions that they believe to be, in good faith, and are subsequently determined to be in bad faith because government perhaps determines that that individual being seen to have acted in bad faith might save government's bacon. If, for example, there are legal issues that emerge. So I'm just trying to understand how the content of this section is de-risking things for individuals and is addressing those kinds of conflicts between, again, fiduciary obligations, good faith, and individuals trying to understand the actual direction of government when it's somewhat unclear.
Attorney General?
So just to explain the mechanisms again, and I hope I'm being clear, I'm being as clear as possible without any political influence in my words. I'm just talking about the way the legislation and the law stands. So the way that mechanism would show up to set a standard would be, first of all, through the procurement directive. So once issued, the procurement directive is done by OIC, and it would set out the standard of conduct that we would expect in a procurement way. So it would say to the government reporting entity, here's what we want you to do. And of course, anything related to that wouldn't be about breaking the law or not abiding by duties, that it would just be about directing procurement in a certain way. And then the next thing is the clear legislative framework that talks about when the indemnity applies or it doesn't apply. So you have the procurement directive that's directing very clearly the conduct that we want them to implement, and then we have a clear legal provision here saying that if you operate in bad faith, you won't get the protection of the indemnity clauses in 8 and 9. And so it provides that guidance of how we expect them to conduct themselves.
Member from Kelowna Mission?
Thank you very much. Again, I'm just trying, I'm not a lawyer, I'm trying to wrestle through an understanding of how this would all play out. In looking at legal precedents, there are cases like Turcon Contractors Ltd. Versus BC Transportation and Highways that addressed issues around the procurement process and, arrived at the determination that, integrity of process is paramount and that arbitrary and political decisions should not weigh in. So I'm trying to understand when the rubber hits the road, how does this stuff actually work, and how do we avoid a situation in which, despite the fact that there is an attempt to protect against the legal proceedings, there is a direct incentive for a government that provides a broad but fuzzily defined political direction to hang individuals in GREs out to dry if and when something goes wrong and there is legal risk.
Attorney General?
I first want to offer the member kudos in providing case law and a quote from a case. Impressed. Okay, so again, the case that the member quoted that talks about the integrity of the process and the paramountcy, all that law applies, right? That's out there and part of the law of the land. The way that this would operate, again, is that instead of a scenario of hanging out people to dry, instead we're actually giving them clear guidance and protecting them in the case that they operate under the directive and something, they incur any claims against them. So it's actually the opposite of that. And what it also does is provides clear instructions in the directive. So we are setting that standard of conduct in the directive and then making sure that they do not, that they know if they operate in bad faith, that there would be, the indemnity wouldn't apply. So, yeah, so the structure of it does provide that clarity to everybody. And I also know that the structures of government will be there, so just operationally, that we would provide any government reporting entity under a procurement directive would have the support of government to help to understand how they're applying it and would answer any questions.
Member from Kelowna Mission?
Thank you very much. I appreciate that. And one day, if I ever apply to law school, I will definitely be putting that kudos from the Attorney General in my application package. Meanwhile, I will probably avoid that for now. So I firstly, thank you for the answer. I do appreciate that. That's very helpful. What I'm trying to understand and assess is what the risks are here, recognizing where the Attorney General is coming from in terms of what she said about not trying to hang people out to dry. The reverse issue is also one where we get into challenges and we think about protection against legal proceedings for individuals who are complying or intending to comply with directives. Now, what happens when those directives go sideways and when good intentions turn into abuse? So I would remind the Attorney General that the sponsorship scandal federally started as perhaps arguably a good faith effort to ensure the unity of Canada, and it degenerated into a massive scandal that shook the foundations of Canadian politics. So when we're talking about protections, when we're talking about direction, when we're talking about intent to comply, I just want to understand how we are de-risking the possibility that what starts as an effort to put Canada first, to put BC first, to cut the U.S. out of procurement, how are we protecting against the possibility that snowballs into an initiative that becomes politicized and then ultimately finding ourselves in a situation where a year, 2 years into a program that ultimately becomes politicized, that ultimately has the risk of manipulating or influencing procurement processes on a domestic basis, then ends in a scenario where potentially that happens, it all goes wrong, it snowballs into a scandal. There is demand for public accountability, but what government is doing through this is protecting anyone who might have participated in so doing. So I want to understand kind of where those thresholds are and where the guardrails are against this bill being used to create unaccountable politicization, or the risk of unaccountable politicization and the use of the public purse as an instrument of domestic politics, that first started as an instrument of defending against America, that first started as an effort at economic stabilization. How are we mitigating against those very real risks?
Attorney General.
Thanks for the walk down history lane about the sponsorship scandal. So we are, there are a few ways that this is, there's protections built into this legislation to make sure that we're over this enabling a really fair and transparent process. The first one I'd say would be the steps that we talked about the last time we were at committee stage that were about the financial all the acts that still apply to any procurement directive, and we went through that over in quite some detail. So that the kind of the guardrails of the financial accountability and all those systems still being in place through a directive. The other thing I think it's important to remember is that the procurement directives they're not meant to say don't do procurement in a fair way. They're meant to say do your procurement this way. So it'll be clear in an OIC that will be transparently out to the public and published that we're saying to those GREs, here's how we want you to do your procurement. Then again, if there's any, we talked about that already, if there's any bad faith or claims of that, then the indemnity provisions don't provide. And I think two other points that I'll make, and one is that this is a bill that's flexible. So it gives the ability to change or alter procurement directives in the future. So if there is a scenario where something has gone awry and government wants to fix that, they can issue another procurement directive that makes it clearer. So the flexibility that's built in for that does also prevent that. And then just a final point to saying that nothing about this escapes the government from liability if it acts in a way that's improper, right? That we are shifting it away from the government reporting entities to if they're following our procurement directive. But we are not, there's nothing in here about the government not being able to be sued or claims made against it for any improper conduct.
Member from Kelowna Mission.
Thank you very much, Madam Chair, and I appreciate the answer from the Attorney General. But what I'm hearing is that direction from government can be, here's what we want you to do. It doesn't matter whether the direction is positive or negative in the form of here's what we want you to do or here's what we don't want you to do. Positive direction can be used to reward and punish or to pick winners and losers in procurement. And from what I understand from prior characterizations of the bill made by the Attorney General and by others, the intent really here is to punish America or Americans or American companies for the sins of their president. But the same toolkit, the same forms of direction that can be used to punish America, Americans, or American companies can very easily slide into being used to reward and punish domestic actors, domestic companies, domestic individuals involved in procurement, involved in regulation, or to pick winners and losers. And it would require a level of naivete not to know that it is eminently possible, for example, for a government to specify a procurement process in a way that picks winners and losers. We spent considerable time and ground going over the fact that in the course of all of these changes, government made choices to seemingly remove any engagement or consultation with open shop labor from their consultation, from their working groups, from their processes. So we canvassed that issue in quite some depth. It became clear that it was a matter of some discomfort for the government and for the Attorney General. There was no consultation with open shop labor. So already in the drafting of this bill, government was picking winners and losers in terms of who it deems to be a valid and relevant stakeholder to be engaged in the construction of this bill. The Attorney General was clearly very uncomfortable discussing the subject of the union dues of Canadian workers rolling up to American head offices and being donated to Donald Trump. So those are political choices. The choice not to engage when it comes to carving out American content, the choice not to engage with the fact that labor workers in Canada are having their dues donated to Donald Trump, that's a political choice. That is a choice that is arbitrary, that uses the power of government to engage or to disengage with certain groups. So you can see why I would have concerns around the arbitrary use of these powers to reward and punish at a political level, not just on a geopolitical international basis, but domestically. And again, my concern is that having granted itself broad discretionary powers and flexibility, as the Attorney General described it, having significantly reduced oversight and having then granted legal immunity, I worry that this is a recipe for very significant politicization, the risk of politicization or the perception of politicization in procurement processes that could have not just the stated international geopolitical aims, but also domestic political and commercial consequences that could either be, again, politicized or could be contrary to the fiduciary interests of the province. So I'm trying again to understand those guardrails, and I hope the Attorney General can help me to illuminate that a little bit more.
Attorney General?
Thank you. I have answered this. It's unfortunate that the members using this time that we have to go through the content of clause by clause of this bill and help the public understand it to make very unsubstantiated and grandiose political claims about our motives. I found it unhelpful. But just to say that I have answered this question in detail about through Clause 7 debate and through Clause 8 debate, and I've never been uncomfortable answering a question.
Member of the House Leader of the Third Party.
Thank you, Madam Chair. I have a question I just want to confirm. We had extensive discussion in Clause 7 on the procurement framework across government. It's a comprehensive framework. It's designed and operates to prevent abuses of procurement along the lines my colleague described. The Section 8, or Clause 8, simply deals with providing protection in relation to the exercise of a directive, a procurement directive, which is still subject to all of the other regulatory frameworks. So my question through you, Madam Chair, to the Attorney General is, given that this deals with a directive, is it true that if a enthusiastic public servant were to go out and do something political that my colleague is saying might happen, that the rest of the regulatory framework would address that, and that falls outside this directive?
Attorney General?
I agree with the member's characterization.
Member from Kelowna Mission?
Thank you. I resist the notion that this is somehow abstract or broad or not directly related to the section here. I think the overall thrust of debate on Bill 7 has really been about power and accountability, and there seems to be a disinterest in engaging with some of the really profound political and legal and philosophical consequences here. So again, this protection against legal proceedings section has the effect of reducing incentives for internal accountability. It has the effect of increasing the likelihood of risk-taking behavior on the part of individuals at procurement, designated procurement entities, government procurement entities, who might, again, be zealous in their efforts in such a way that advances a political objective if the signal to those individuals is that there is protection against legal proceedings, and there is a very clear identifiable risk of the politicization, the domestic politicization of these processes for partisan political gain or simply for values-based political action. Again, you're reducing the incentives for internal accountability. You're raising the bar for legal challenges, and you're creating a situation where plaintiffs must prove bad faith. So I'm really just trying to understand, again, the potential risks here. I I fail to understand why the Attorney General does not see the parallel to the sponsorship scandal, in that there is now a situation where vast millions and billions of government dollars are going to go out the door through procurement processes, and it would really only take one individual, one bad actor, a handful of bad actors for millions, tens of millions, or hundreds of millions of taxpayer dollars to be misspent, politicized, or perceived to be misspent or politicized. So this matter around accountability and around protection against legal proceedings and around the risk of severe politicization is very worrisome. So again, I really want to understand what discussions were had around de-risking that politicization, what discussions were had in the development of this bill, and specifically of this section, to make sure that we're not creating a recipe for a new sponsorship scandal at an even higher dollar level.
Attorney General?
Yeah, I've already talked quite a bit in the long number of hours we've already debated on the procurement. Maybe I'll ask the member if he can walk me through which sections of the bill are in this procurement part that he thinks would lead to the scenario that he's describing, because I've talked through all of the safeguards and protections that actually prevent that from happening. So it would be of assistance to me if he could point to the provisions that actually wouldn't. And I again say that nothing in ESTRA or this bill would take away from the procurement regulatory environment that exists.
Member from Kelowna Mission.
Thank you. I don't think it's necessary for us to relitigate past portions of the bill, but I do, again, what I'm focused on here is this section, the protection against legal proceedings, and the very real possibility of there being, whether it be, it need not be a politicization, it could be an individual taking advantage of quickly marshaled procurement directions from government to enrich themselves or their friends. Again, it could be political, it could be any of those things, but I really, again, I fundamentally am focused on the protection against legal proceedings and on the risk that any one of a number of different untoward circumstances that could emerge from this very broad bill that provides a tremendous amount of discretion and flexibility. What I'm very worried about is that we're reducing incentives for internal accountability, we are raising the bar for legal challenges, and we are creating a situation where individuals at government procurement entities could very well feel, rightly, wrongly, they might very well feel that there is a lack of accountability for them to push the boundaries of directions provided by government. And I go back to the fact that this is how the sponsorship scandal started. This is what happened. You had millions of dollars that were supposed to be spent on national unity that found their ways into the bank accounts of politically connected firms and individuals. And that started with the same kind of language around how nothing untoward is going to happen, everything is clean here, and it took down a government and shook the foundations of Canadian politics. So I really think it's very important that we take this section seriously and that we think very actively about whether these protections are overbroad or reduce accountability, reduce responsibility, and empower people or free people to engage in politicization of processes or in the use of processes to enrich themselves.
Attorney General?
Thank you, Chair. The member has not provided me with any specific clauses beyond what I've already walked through in detail that would lead me to have a different answer than what I've had to the previous question. So I would say asked and answered, and if we could move on to other questions.
Member from Cologne Mission.
Thank you. I will change the direction of my questions and be very specific. Will the Attorney General commit to commissioning and providing a report on the lessons learned from the federal sponsorship scandal and how they will be applied to ensuring accountability in the context of this overbroad bill? I think it's very important that we learn from history in terms of what happens when a government starts allocating funds toward a political objective that is deemed to be nonpartisan, that is deemed to be existential for the country, and that has the risk of snowballing into something very serious. You know, when I see cabinet ministers on the other side of this house snickering and laughing at the idea that we ought to be concerned about accountability, shaking their heads at the idea that their government could ever go awry, that really worries me. It strikes me that there's just a level of entitlement that is set in and a level of belief that they can do no wrong and that anything that is in the pursuit of their political or policy objectives is acceptable. And that's the exact kind of thinking that got us into this overbroad power grab of a bill that was systematically pushed back on by just about every stakeholder in the entire province. That's why they're sitting here chastened with a watered-down version of their bill that's still overbroad, and with thousands and thousands of people that have lost trust and confidence in this government as a result of their overbroad Bill 7 assault on the basic fundamental tenets of democracy and accountability. So I would ask the Attorney General again, will she have developed and table a report on how the lessons of the sponsorship scandal are being applied to making sure that appropriate safeguards are enacted around these procurement powers to make sure that there is neither politicization or personal enrichment happening and that there is due and appropriate accountability accompanying the kinds of powers that are created by Bill 7.
Member, I'm unclear how your line of questioning specifically relates to this section.
Very happy to outline that. Again, one of the main issues that happened with the sponsorship scandal was that there was a feeling of impunity. There were well-connected political insiders who were benefiting from dollars being dispensed in the name of national unity, and that when all was said and done, there was a considerable legal and political fallout in which there were questions and uncertainties around accountability. That particular scandal led to extensive reforms in Canadian politics. It led to extensive changes in a whole bunch of different legal structures around politics and around procurement. And it had very, very material consequences. And I don't see any indication that the Attorney General, that this government remembers those lessons or has learned from those lessons. So since there is an ambivalence and a disinterest in body language that suggests that this government doesn't take that inquiry seriously, I really do hope the Attorney General will commit to take that walk down memory lane and to go back and to review the lessons of the sponsorship scandal in a real and serious way and to bring us back some report, table of report on how the lessons learned from the sponsorship scandal will be applied to making sure that we don't see the same kind of abuses and the same kinds of consequences and the same kind of lack of accountability that we saw all those years ago with the sponsorship scandal. And again, I think that relates very directly to this section around protection against legal proceedings and around questions of the definition of bad faith, questions around language involving complying with or intending to comply with directives. So I really just hope the Attorney General will take this question in the good faith with which it is offered and provide us with some understanding of what, if any, conversation was undertaken in the development of this bill to make sure these kinds of protections were put in place. And if, in fact, no such conversations were undertaken, I certainly hope that they will be undertaken and that we'll see some report on how those safeguards are going to be enacted.
Attorney General?
I find it surprising that the member's asking about me conducting a review in British Columbia of something that happened in another province when I was 13 years old, but here we are. So I would just say no, and if the member wants to point to any scenario in the decades-old sponsorship scandal that he brings up where there was something related to Clause 8, specifically regarding statutory immunity provided through procurement directive that would make that issue that happened decades ago relevant to this matter.
I apologize. I'm actually going to call a 5-minute recess. and then we will come back. On Bill 7, back to order, we are on Clause 8. Clause 8, shall Clause 8 pass? Aye.
Okay,
Just ask a stupid question.
okay. All right, so I'd like to go to the actuals. Before I start, I'd like to say thank you to the Attorney General and the staff. They've been fairly patient with us while we try to understand this bill and the different clauses, and while we try to provide information to the people that are listening at home. And so thank you for that. And so I'd like to go through the actual clause in terms of the wording. And so basically, going to Clause 8, it states, subject to subsection 2, no legal proceeding for damages, lies, or may be commenced or maintained against a protected person because of anything done or omitted in complying with or intending to comply with a directive issued under this part. So my question specifically is to no legal proceeding. So legal proceeding, can the Attorney General elaborate on the definition for legal proceeding? What exactly are you referring to? Are you referring to Supreme Court actions, notice of civil claims, provincial court actions, notice of claims, arbitrations, contract disputes, ongoing contracts, some people trying to get certain remedies or doing set-off clauses in contracts. So basically trying to get the meaning of the legal proceeding in this particular clause.
Attorney General?
Thank you. So important to read the two words after that. It's no legal proceeding for damages. So it's any proceeding that is one for damages that would be brought up.
Member from Kelowna Mission?
Thank you very much. I'll return to my previous line of question and discussion, and that is the sponsorship scandal. The Attorney General seemed to believe that the learnings from the sponsorship scandal had no bearing on this situation and was looking for some direct comparables. I will draw to her attention that coming out of the sponsorship scandal was the Federal Accountability Act of 2006, as well as public works contracting reforms, significant changes that reduced discretion in spending, and that increased whistleblower protections. So a whole bunch of changes were made to federal procurement accountability and oversight that actually went in the opposite direction of what Bill 7 is doing. And in fact, I would specify that at that time, in the context of the sponsorship scandal, you had legal proceedings, you had the ability to have legal proceedings, and that led to accountability. In fact, specifically, Chuck Guite, the senior bureaucrat overseeing the sponsorship funds, was actually charged and served jail time. So that was a pretty high level of accountability that occurred as a result of the sponsorship scandal, and I would be totally clear that this particular section actually removes that accountability. So the reason why I bring the sponsorship scandal forward is that what we have is a reduction in accountability in a situation where vastly more, millions and millions of dollars, taxpayer dollars, are actually being exposed to the risk of politicization or misuse. So it appears as if Bill 7, rather than having learned the lessons of the sponsorship scandal, is actually pulling in the opposite direction, again creating less accountability, less transparency, more latitude in spending, less clarity in terms of contracting, and actually, again, diminishing both accountability and the perception of accountability in such a way that those hard-earned lessons of 20 years ago seem forgotten. The minister seems to think that's ancient history, but as a lawyer, I would hope that she would recognize that our laws are built on a foundation of things that happened in the past. Reforms that happened 20 years ago matter today, and Bill 7 is undoing those reforms that happened as a result of one of the most egregious political scandals of the 21st century.
Attorney General?
So what we just heard was a misunderstanding of this clause and how it provides. And I didn't see a clear link between that scandal that he's mentioning and what we're doing here. But I would just say, I think the misunderstanding is rooted in what Section 8 actually does, which is not anything to do with criminal charges or helping or making people avoid criminal liability if that exists. It is related to legal proceedings for damages. So it's a very specific thing that we're talking about, and is not related at all to what the member is talking about.
House Leader of the third party.
Madam Chair, this deliberation is off topic. The legislation that was in effect during the sponsorship scandal is federal legislation. We are not here today to evaluate the effectiveness of federal legislation. We are here to look at Clause 8. We had an extensive discussion of Clause 7 and the regulatory framework, in particular Clause 7 sub 2, where there are extensive safeguards in place in British Columbia that apply to procurement, and Clause 8 deals with the provisions still apply to the directive, except in a limited circumstances of damages related to a legal proceeding where the protected person does something in bad faith. I submit that this line of questioning by my colleague is not on topic for Clause 8. And to the extent that parts of it may be, respectfully suggest that the Attorney General has answered in detail either in Clause 7 or Clause 8. So I would see this as not on topic.
Thank you, member. One moment. Member from Kelowna Mission.
Thank you. I'm not a lawyer, but there's one sitting next to me, and my understanding is that we're in Canada here, and that when we don't have court cases in British Columbia, we look to other provinces and to federal cases, Supreme Court cases for precedent. So I'm simply looking for precedent to quit cases and issues that have proceeded elsewhere. I would also say that if there is a situation where there is an abuse of this process, that it is highly likely that legal proceedings for damages may very well proceed in parallel or become precedent to a criminal case proceeding. There's a high likelihood that if there was some form of abuse of the system, it's very likely that both forms of proceedings might very well move forward. So I really see this as being highly relevant. I really do think that, again, a lot of the time, these kinds of major scandals don't start with criminal charges. They start with administrative processes. They start with an individual whistleblower spotting something that just doesn't seem quite right, spotting an impropriety in procurement, spotting an issue. So again, I just come back to the fact that there is a significant overlap there. If there are abuses here, we want to make sure they're protected. And I am just absolutely gobsmacked to hear the Attorney General reject as ancient history a pretty earth-shattering political scandal that divided our country 20 years ago, as if that doesn't have relevance. And take into account that in several ways, this is a more escalated version of that situation. In that instance, we were talking about, frankly, chump change compared to the millions and billions that are likely to flow through procurement under the rubric of the powers enabled by Section 7. So the quantum of dollars is dramatically larger. And I would argue that that Canada's place in the world is a dramatically larger situation than the issue of national unity that was playing out at that time. So, we're talking about a Team Canada situation. We're talking about the same basic conversation. This government likes to wrap itself in the flag and talk about Team Canada. And guess what? The sponsorship scandal started with people wrapping themselves in the flag and talking about Team Canada. Being on Team Canada does not excuse creating conditions where procurement can be abused or politicized and reducing accountability that could well end up leading to criminal charges if there are abuses. So I would ask the Attorney General again, will she in fact develop and table a report on how lessons from the sponsorship scandal. Are we on the point of order? Well, in that case, I'm pretty darn sure that what I'm talking about is pretty darn relevant, and I've just outlined exactly why, and I'd like to continue talking about it.
I've heard both members. I do believe at this point that the line of questioning is now a risk of becoming repetitive. So I think we perhaps should pursue other line of questioning.
Very well. Given that the Attorney General seems satisfied that all the right protections are here and that there is no possibility of things going wrong, I wonder if there were to be a procurement scandal that emerges from this in much the pattern that I've described, would the Attorney General waive her own protection against legal proceedings?
Attorney General?
I don't have any protection under this provision.
Member from Kelowna Mission?
Very well. Having determined that fair, if there is in fact a major procurement scandal on the order of the sponsorship scandal that plays out as a result of the unchecked powers created under Bill 7, will the Attorney General resign?
I will call that question out of order. In terms of relevance. Member from Richmond, Queensborough.
Going back to Clause 8, and we were just talking about the definition of legal proceeding, and the Attorney General was kind enough to provide an explanation for the definition there. Going further, in Clause 8, subsection 2, subsection 1 does not, subsection 1 does not apply to a protected person in relation to anything done or omitted in bad faith. And that the definition for protected person is up in 6, sub B, a person who is a member, director, officer, or employee of a government procurement entity. Now, I know that I know that the phrase is referred to in here, protected person, but in Clause 8, in regards to Clause 6, I'm just wondering why there was like a whole bunch of different classes, such as like member, director, officer, or employee of a, when you're talking about all these different entities and they all seem to be part of the government procurement entity. So I'm just have a query here in terms of this.
Attorney General.
Thank you. So the reason behind the definition of protected persons being so broad was to make it clear that if any of those member, director, officer, employee, any of the ones listed were operating in accordance with the procurement directive and not in bad faith, that they would be protected. It's likely that they have other protections that they could avail themselves of that are to do with other laws and potentially insurance, but we just wanted to make it really clear.
Member from Richmond, Queensborough.
The follow-up question I had to this when I was reading it, like why I asked this question was, it specifically refers to member, director, officer, or employee. And it seems to be exhaustive list, where it doesn't say that, or any other person. Can the Attorney General elaborate further on whether this is exhaustive list? And if it's not exhaustive list, why did the last term not say and any other person?
Attorney General.
So the policy behind that was to try to make sure we were capturing everybody that might be involved in the work of procurement. And it is an exhaustive list. Member, director, officer, and employee really does include anybody that we could contemplate that might be involved in the actual act of doing the procurement.
Member from Richmond, Queensborough.
What if there was a situation, sometimes in employment situations, there's people that are employees, but then there's subcontractors, independent operators. So that comes to mind. And if this is exhaustive list, how does that apply to, like, say, an independent operator?
Attorney General.
So a few answers to this. So first of all, I would say it's unlikely that a contractor or subcontractor would be the entity that does procurement or has a role in procurement. But if it was the case, then there would be a contractual relationship between the two parties, and that would be an opportunity through that contractual relationship to help clarify any indemnity provisions that were provided through that contract to that entity. And the next thing would be is that because it's written pretty clearly in the legislation, it gives every government procurement entity an opportunity to design their affairs in a way that would make sure that they are, can avail themselves of the indemnity provisions, so that these member, director, officer, employee are involved in procurement.
Member from Richmond, Queensborough.
Just a follow-up to the situation of an independent contractor, independent operator. or subcontractor, if you will. And what was mentioned was that there may be a contract between the general contractor and the subcontractor, or the employer and the independent operator. But there's nothing in this legislation that says there has to be an actual provision of a contract between an independent operator. So how does that independent operator get protection if a certain entity does not provide a contract to that individual?
Attorney General?
Could we just get some clarity on the member's question a bit? So we're trying to, before we answer, understand what the independent contractor, what role they might be playing in procurement, or the procurement directive before we can formulate an answer.
Member from Richmond Queensborough?
So the question goes directly to government procurement entity, and the definition of a protected person includes a member, director, officer, or employee. And I was told that this is an exhaustive list. So my question was, what if there's an independent operator? Sometimes the lines aren't very clear between employees and independent operators. It comes up on a regular basis with employment standards, whether that person was actually an employee or were they an independent operator. And sometimes there isn't even paperwork. And so somebody could be doing the exact same duties of an employee, whatever employee has to do, but they could be considered independent operator. They're on a contract. They could be on a contract, but there's no written contract.
Attorney General.
Hello, welcome to the chair. So my answer from before stands. There's a whole bunch of ways that I think the member is talking about independent contractors and employees, and there's a whole bunch of ways that an independent contractor could be doing actual employment, and that's a factual analysis, right, of whether they land on either side. So I would say that scenario was unlikely, and then even more unlikely without a contract. Like if you were going to ask somebody to do something that's as big as participate in a procurement of a organization, likely to be an employee, but let's say there's a scenario there's no contract, as the member describes, and they've also been asked to do something related to procurement. In the event that there is an action for damages, so legal proceeding against that either organization or individual, so that's the scenario we'd have to play back. If there's then they could countersue the organization, which in then case would get potentially the indemnity of these provisions or a provincial role in that. So it would backtrack itself. But for that scenario to happen, there would probably have to be multiple examples of bad business practices of doing those kind of things without a contract, which I would say in the environment of government reporting entities, which are organizations that are under a lot of rules, with their reporting would be unlikely.
Now that we're on this point about employees, independent operators, another situation that comes to mind is you often see unpaid workers, or not unpaid workers, let's just say volunteers or interns, and they may be involved in making certain decisions. I know in the legal profession we have article students, and article students are not lawyers, but they make certain decisions on certain cases. And so if you had such a situation as a volunteer or an intern, or I don't know if it's possible to have an articling student in this situation, but say if there was something like that, how would they be treated?
Attorney General.
Okay, so it starts by the thing that I already talked about, which is that it's very clear in the legislation who we're providing that protection for. And I think it is, when you do this kind of thing with indemnity, you do want to be certain about how, and so we're setting a standard right there. We're saying, like, if you're going to issue the procurement, have people do the procurement directives, don't make it be people like volunteers or independent contractors. This is how we're assuming you're going to conduct yourselves if you want the protection. And I think that also is a level of protection in itself. But the principles that I talked about before would apply in events that are unlikely. Government procurement entities, we're not aware of any that would have scenarios where employees wouldn't be doing, they would not be employees and they would still be doing important work like procurement. Or participating in a procurement process. So we can't imagine a scenario where that would be true. But in the event that did exist out there, then my previous answer about the steps that could be taken applies.
Member for Richmond Queensborough.
Thank you for that answer. And that flows to my next question here. The Attorney General mentioned something about there's a certain standard that these government procurement entities should know about, and if they follow that standard, they stay out of trouble. So that leads to my next question. It has to do with knowledge of this particular provision, because this talks about protecting certain people that are in a prescribed class. And so the next question goes to consultation. The Attorney General mentioned that she is not aware of any government procurement entities that would have independent operators and all that. In my mind, that brings the issue of consultation. Whether there's been consultation had with all these government procurement entities and people that are going to be expected to carry out provisions, and that may be looking for protection against legal proceedings. And so what has been the level of consultation in regards to this particular section? So the Yeah, so the relevant entities know what protections there are.
Attorney General.
So we've talked about the consultation quite a bit about what led to this bill, so I'm not going to go over that again, but I think we have to remember that this is an enabling statute. It enables the government to do certain things, and one is to issue a procurement directive. When it decides who to issue the procurement directive and how to issue it, that's the opportunity for consultation for that particular GPE. Or that sector, or however the enabling powers are set to be used.
Member for Richmond Queensboro.
Thank you for that answer. So I understand it's an enabling statute and enabling provisions. And I understand at that point when a government procurement entity gets involved, they would probably learn about this process. So would that be on, would that effort be on the government side to kind of, train these government procurement entities to make sure they understand the proper parameters, if you will, of these legal protections?
Attorney General.
Yeah, so we would have internal structures in place, along with the directives, to do exactly things like the member suggests, is to help procurement entities understand the directives and what they're expected to do.
Member for Richmond Queensboro.
What would those training sessions or knowledge sessions look like? And what would the procedure look like?
Attorney General.
So the way it would be up to the ministries that they would do. I don't have that answer because this is right now, my job is to give the enabling powers to the ministries to do the work. So that would be up to them, but I would imagine it would be a chance, once you've issued a procurement directive, to contact the government report or procurement entity that's under your ministry and do presentations and talk through what it means and ensure that they understand.
Member for Richmond Queensboro.
I appreciate that answer, but when it comes to legal protections, a lot of people don't like to rely on verbal assurances or words because there could be pretty stringent legal repercussions, and they want to actually have those protections in place. So if not in here, is there somewhere else, are we going to be getting more information throughout this bill of what those standards are going to be on the ministers to make sure these government procurement entities are going to get the training, and that training is going to be specific so they understand what their protections are?
Attorney General.
Yeah, so I think to understand the government procurement entity's relationship with government and the ministries they sit on, I think helps to understand how actually the ability to ask questions and be engaged is is pretty close and direct. So first of all, government procurement entities would have their own legal counsel and ability to do that, but the connection they would have with their ministries to ask questions, to make sure they understand the procurement directives, to understand the content of it would be a high level of sophistication. So it's how we operate with these procurement entities already. There are relationships with all the ministries and these entities that are not only about financial reporting, but many other things.
Member for Richmond Queensborough.
It's my understanding that these types of provisions that we're now dealing with in Bill 7 are unprecedented because we're dealing with unprecedented times. And what was kind of explained, my understanding of it anyways, is that it will be approached, it involves a high level of operation where these entities have their own legal counsel. But that all seems like there's no stringent guidelines or no stringent framework for these entities to actually get that legal advice. And why this is important is that, looking at it from the legal lens, a lot of people go to lawyers to get legal advice, and they don't want to act because before they actually get that legal advice is because there could be consequences. And that's the whole premise of getting legal advice, and at times get that legal advice in writing. But here, with this situation, it is magnified 1,000 times further, because we're dealing with unprecedented times, and we're dealing with not just like thousands of dollars, we're dealing with not only millions of dollars. I think it was the words of the Attorney General that the amount of money that could be involved with these procurement could be up to like $600 million. So, which involves like a situation that could lead to drastic legal consequences. So from my example of people going to lawyers for legal advice on smaller matters versus this, now we're dealing with unprecedented times. We're dealing with unprecedented amount of money in regards to the provisions in terms of procurement in this bill. But yet, it seems that we don't have a clear, concrete framework of how people are going to get their legal advice. Like we were just going through this definition of protected person in Clause 8, Sub 2. And that led, I was a little bit confused myself, so that's why I asked for a clarification on what does protected person mean in terms of this clause, member, director, officer, employee. That's just one thing, but now I'm going even further. I'm talking about the actual legal advice that is going to understand this provision to actually be protected, but it seems that there's no guideline. So will there, if there are no particular guidelines right now or a framework to tell ministers that you have to provide this legal advice, so that people have to understand which people are included in the protection, which people are not included, will that be coming in the near future? Will that be a regulation that's drafted? Has there been any discussion on that?
Attorney General.
Okay, so I'll start by saying that the only thing they really need to understand is a few clauses, so I don't think it's complicated for the level of organizations we're talking about, health authorities, BC Hydro, ICBC, who have, organizations like that have regular procurements, legal teams. It's not they're pretty sophisticated. Not only that, they're very closely associated with government. So working with government is a regular thing for them. So there's lots of precedents for the type of provision that we have here with providing immunity for certain things, and it's very clear what this one is for in the wording of it. And that precedent sits as it is, and I don't think there's any other precedent of it being associated with any requirement for a minister to make sure that legal advice is provided to the entity for which that indemnity might apply. So we think we have the right safeguards and the right protections in place, and in the event of and as I mentioned, as this rolls out, that relationship and the explanation of the procurement directives with the ministries, with whatever the government procurement entity that exists in there, would be a way to communicate with each entity.
Member for Richmond Queensborough.
So is the Attorney General saying that there's going to be no further safeguards in explaining the legal protections under this act to government procurement entities?
Attorney General.
So we've had an extensive conversation of all the safeguards that are in place with respect to this provision, the procurement directives, and the transparency that's involved with all of this. So it's my view that the level of protection in here is strong, and it's going to help all of our procurement entities and government move together in the same direction and unlock the potential of procurement in this province.
Member for Richmond Queensborough.
With all due respect, the previous discussion had to deal with like what are the safeguards from this legislation. Now we're talking about those people that are going to actually implement this legislation. We're talking about the safeguards for them. So I respectfully disagree that the prior discussion applies to this. This is talking about who's going to carry forward this legislation and the provisions. So, so back to the question: are there going to be no further safeguards to explain the legal protections to these government procurement entities that are carrying out these directives?
Attorney General.
Okay, so I'll give one more shot at talking about the safeguards that I mentioned that are in place related to this. So it starts by the OIC, the procurement directive will be published as an OIC and transparent in all its guidance. With respect to the immunity clauses, this is very common and will deputy ministers, and I talked about this already, the relationship with the government procurement entities in terms of presentations, ability to answer questions that are related to that. And there's a lot of precedent for the type of relationship that we have with our government procurement entities and working together in many different ways. So there are, in my view, the safeguards are in place are appropriate for the type of relationship we have, and clear and transparent, and will help us move forward.
Member for Richmond Queensborough.
So I'm still left with a unclear understanding. So is it the position of the Attorney General there will be no further safeguards the safeguards that we have right now to inform these government procurement entities, that's where it will remain, but then there will not be any further safeguards?
Attorney General.
I've answered this question already, Chair.
Member for Richmond Queensborough.
I respectfully disagree to that. I don't have the understanding of that. The understanding that I do have is the answers that were provided before was talking about safeguards from this legislation. And there's been explanation that, you know, a roundabout explanation, but I was just asking a clear answer to a clear question. No further safeguards or safeguards. Further safeguards or no further safeguards? Just plain answer to that.
Thank you.
Attorney General.
Yeah, so I have answered this question. I talked about all the safeguards in place, and we've canvassed this question, and I believe I've answered it.
Sorry.
It's-
Member for Richmond Queensborough.
So it's my understanding there will be no further safeguards because the explanation was provided, all these safeguards are in place. So there will be no further safeguards. Just for the record, for the people watching, that's what my understanding is. As I was just told, my question was answered. And that's the understanding I have. Would the Attorney General like to clarify that, or is that correct understanding there?
The member may not agree with the answer, but the Attorney General has given her answer.
So to go further with this provision, there's other language here that is a little bit ambiguous. Now, in subsection 1 of Clause 8, subject to subsection 2, no legal proceeding of damages, lies, or may be commenced or maintained against a protected person. That's great. We spent some time on that. Because of anything done or omitted. Now, the word anything is a bit vague. Could I get some explanation on that?
Attorney General.
To the member's question, it's not just anything on its own. The word anything is to be read with because of anything done or omitted in complying with or intended to comply with a directive. So it's designed in a way to be broad enough to capture actions that might be taken in accordance with the way it's written.
Member for Richmond Queensborough.
So I now get that this legislation's intent is to be very broad. Thank you for that explanation. Going on further, because of anything done or admitted in complying with or intending to comply with. So I understand complying with, that somebody either complied with something or they don't comply with it, but intending to comply with, that sounds very ambiguous in terms of this could leave a big room to interpretation of what that actually means. So I need an explanation on that, please.
Attorney General.
Okay, yeah, thanks for the question. You have to understand intending to comply with a directive in the context of also what we're excluding. So in the legal sense, intending to comply with a directive means that we want to make sure we protect people from honest mistakes that they may have done, or genuine, error. They were genuinely trying to comply with the directive and something happened. And that is qualified by the subsection 2, which is excluding the bad faith. So it helps you understand what's in the context by understanding what we carved out. And we talked about bad faith, I think, in a previous question, and what that covers. So that's the reason behind it.
Member for Richmond Queensborough.
So going back to the previous question and how it relates to this, I was asking about the legal advice, the legal protections, knowledge that is bestowed upon people that are going to carry forward the legislative provisions here, the directives. So now going to this provision, it talks about catching some people that have they're exercising good faith. They're trying to carry out these directives, and they may not have known what they were actually doing, but they had good faith. But going back to that question of is there going to be a proper safeguards in place and a framework to actually teach these people so they have the proper training? If they had the proper training, and my understanding is from the Attorney General that they feel pretty confident that Attorney General's office feels very confident that these procurement entities will be able to carry out these directives, and they will know what they're actually doing. So if they will be actually knowing what they will be doing, then what's the purpose of having this in here, intending to comply?
Attorney General.
Yeah, it's to cover any honest mistakes. It's like that sometimes mistakes made, but they're genuine in the sense that they weren't intended and they were not in bad faith.
Member for Richmond Queensborough.
So that explanation really doesn't make sense to me when earlier the Attorney General explained that these procurement entities will understand. They're highly sophisticated. They will understand the safeguards. They will understand the legal consequences. They will understand the legal protections. And now on the reverse side, I'm being told now that there might be some people that are not going to understand. They're going to make mistakes, and they need protection too. So that those two ideas, they converge with each other. They don't make sense. They're two different, they're going on two different paths, those two ideas. They don't make sense at all. So going further onto this point, I understand complying, but intending to comply, that seems to be conflicting with the other explanation that I received. So going further on this, my understanding so far on this clause is it's pretty broad, as I confirmed with the Attorney General's broad coverage. But there are some problems in terms of certain people that may be carrying forward these provisions. They may either know what they're doing or they may not know what they're doing. And that seems to come out from this debate today. So the follow-up thing to this that I want to kind of talk about is further that on the next part of this clause in subsection 2, it talks about bad faith. I know the Attorney General did spend some time talking about bad faith. What does it actually mean? And then the Attorney General just spoke about right now about good faith, certain people exercising good faith. But if you look at, we're looking at a bill that's involved here, and When we're looking at bills, we're actually trying to create law. So that takes you back to law. And when we're looking at, say, for example, certain areas of law, such as civil law, or we're looking at civil actions and stuff like that, we often hear terms such as negligence, gross negligence, or willfully blind, that, somebody, their state of mind, that they should have just known better. And they shouldn't have some protection because they should have just known better. What they were actually doing was improper. They should have known what they were doing was improper. So I understand bad faith, somebody just making a decision, and they're clearly making a decision because they decide to do the wrong thing. But then there's some people that are so above their heads in terms of carrying out decisions. They don't know what they're doing, and they shouldn't be doing that, because there could be serious consequences. So there could be gross negligence. Why is there gross negligence also not included as a exception here? Why is bad faith only, but why not gross negligence?
Attorney General.
Okay, so to answer this question, we have to start with the laws that attach itself to procurement. So what we're saying with this is that we are going to step in with these indemnity provisions in the context of of an entity or organization or person stepping in to put forward procurement directives. So in the context of procurement directives, it's a contractual thing. So it's not tort, it's related to contractual relationships and how we engage in that process of forming one and all of that law related to that. So in the context of that, the drafters have put the exception for bad faith to align itself with the law related to procurement and procurement practices. Now, in a scenario where there was an issue of gross negligence, as the member raised, it would be very complicated. So if it's not related to procurement or the contractual relationships, then it may not be something that we step into. But let's say there are elements of that tort that's being alleged that lead to bad faith analysis, because there may be overlap, then maybe it applies. But generally speaking, this indemnity is for an area of law associated with procurement and contractual situations.
Member for Richmond Queensborough.
With all due respect, the law around contracts and civil actions or civil law, it interacts with each other. Some of the remedies or some of the terms are loosely used on both sides, contract law, civil law. And with all due respect, if somebody was carrying forward a contractual term, a procurement entity was carrying it forward, humans are involved. Human decisions are involved. And there could be negligence. And that's there. But what's even worse is gross negligence, where people should have clearly knew, they didn't know what they were doing, they could make a wrong decision. It's pretty close to bad faith. And they did it anyways. They did it anyways, and now there's millions of taxpayers' dollars lost. So that's a huge concern. But I understand that the interpretation from the Attorney General's office is that this adequately deals with the situations that may arise just by adding bad faith. But with all due respect, I do not agree with that. And so at this point, I'm gonna move an amendment to Clause 8. And the reason why I'm moving the amendment to Clause 8, it has to do with both subclauses. I had an issue with subclause 1. I talked about the wording between that's stated intending to comply, and I mentioned my reasons why that was concerning to me. And also now, I'm also mentioning why it's concerning where gross negligence is also not included here. And so I'm moving amendment, and basically that's to Clause 8 by deleting the text shown as struck out. So basically I would like to strike out where it states in subsection 1 or intending to comply, and also adding the underlined text to show, underlined text being to add or gross negligence right after bad faith on subsection 2. So that's my proposed amendment. I have a copy of it here that I'd like to hand up. And I could also speak to it too when the chamber is ready.
We'll take a recess to distribute the amendment. Committee back to order. All right. Thank you. So the amendment is in order. I recognize the member for Richmond Queensborough.
So, as I was speaking about earlier, before I introduced this amendment, there's a, from my perspective, there's a serious issue with Clause 8. Subsection 1, I referred to, I went at length at questioning the language used for intending to comply, and I mentioned what my concerns were after the explanations that were provided by the Attorney General. So, and those concerns are still ongoing in terms of that. So that's one of the reasons why I introduced this particular amendment. If this part of the explanation that was provided, it wasn't a clear explanation of why and why it's really needed, this section. So if the amendment proposes to strike this part out, so it will still protect those people that are complying with the act. They know what they're doing, they're complying with the act, they're complying with what they're asked to do in regards to Clause 8. They'll still have the protection. But the explanation that was given for intending to comply, that would be struck out. As for, and in subsection 2, the explanation that I was provided why gross negligence is not included when it could involve a degree of culpability. The explanation wasn't very clear. And now, why I'm extra concerned, if somebody is asking why am I extra concerned, I'm extra concerned is we're dealing with unprecedented legislation. Dealing with Bill 7. We've never had a political climate such as this where we have to create a piece of legislation such as Bill 7. And not only is it unprecedented times, we're dealing with money that is not only a matter of millions of dollars. It's not only a matter of hundreds of millions of dollars. The Attorney General, in a previous part of the debate, I believe, used the amount it could be $600 million, and it could maybe even be beyond that. That's a lot of money, a lot of taxpayer money at a time where this province is really struggling. The deficit is at a level of 10.9 billion, according to the government, but according to many stakeholders and credit agencies, that deficit is actually looks more like $14 billion. And that's money that the government doesn't have and the government needs to spend. So we are in a very grave situation in terms of finances. So now we're dealing with procurement measures that don't have stringent protections, stringent explanations for certain important sections or certain parts of this clause. And so this is very concerning, and this particular clause should be very clear, and the protection should be very, very clear. So so it will become a lot clearer if the words intending to comply were struck out, and also if the words gross negligence and subsection 2 were added. So those people that have a degree of culpability, because they're so grossly negligent, they would not be protected under this. They would not be protected for making decisions that would cost our taxpayers here in British Columbia millions and millions of dollars. And that's in a situation where this province is in dire circumstances financially. So that's why important attention needs to be provided here. There needs to be extra safeguards, and this proposed amendment provides those extra safeguards, and so that there's sound reason to have an amendment in this place. So I urge both sides of the House to support this proposed amendment, to vote in favor of this proposed amendment, because it will allow for more protection about on the mechanism around procurement, and that would eventually lead to safeguarding the process and the framework that is going to involve millions of dollars, several millions of dollars of British Columbia money. So I urge both sides of the House to support this proposed amendment.
Attorney General.
Thank you, Chair. I do not support this amendment, and I'll lay out the reasons for it. So the first one, I guess generally the reason that I don't support either of these amendments is because it diminishes the bill and it diminishes the protections available, and also the protection of the public purse. As the member is articulated, he shows importance as I do. The first reason for that is the removal of intending to comply with. So the reason that I don't support that is that, right, that would leave it as like a strict liability offense then. So if somebody doesn't perfectly comply, then they wouldn't get the protection of indemnity. I don't think that's us operating in good faith with our partners, and would be kind of against the provisions of, or the power of that indemnity. The second one is why I wouldn't support it, is the addition of gross negligence for a few reasons. I would refer the member to the Cripps case in 1990 of the Court of Appeal, which very clearly defines bad faith as including dishonesty, recklessness, and gross negligence. So by adding the term gross negligence to a word that already includes gross negligence, it's in effect, not only is it not necessary, it's actually legally damaging to the definition of bad faith to include only one. So if you only include gross negligence, it diminishes the term bad faith, because as bad faith already includes gross negligence, the question that legal interpretation or legislative interpreter would ask is, why did you include gross negligence? And it leads you down to a legislative interpretation hole, or spiraling down, as to understand the legislative intent of only including one of the elements that are already included in bad faith, and why didn't it include dishonesty, and why didn't it include recklessness. And so therefore completely diminishes the power of the term bad faith, and is also not necessary. So I won't be supporting this amendment.
Recognizing the member for Prince George Mackenzie.
Thank you, Madam Chair. Just wanted to speak briefly about the amendment. And in the context, I want to respond maybe to the Attorney General's comments on the fact of providing immunity in a case of gross negligence. And I understand what the Attorney General has described there. I think in this case, making sure that it is clear that gross negligence is included, is we want to protect British Columbians from negligence of some sort of an entity being protected in the case of an example of a procurement directive that the government has made. We want to make sure that we're protecting the provincial financial situation, but also protecting British Columbians here. So this term is used, of course, in contracts. It's used for insurance purposes. But what I think about it, and I go back to my work in the construction sector, it is used in contracts, in prime contracts, and I've discussed those in detail as part of this debate and in this clause of the bill overall. But what I really think that gross negligence needs to be called out specifically is because we want, in speaking my role as a critic for Ministry of Labor within our official opposition caucus, the safety of workers, gross negligence and the protection of workers is something that we should defend against and make sure that we're not immunizing people or actors or business if there is gross negligence leading to unsafe practices or unsafe actions that have led to things that have hurt workers. So, for example, if a worker is killed because of gross negligence, That's something we want to protect against. We shouldn't provide immunity in this case because of that. The same thing can be said for environmental protection. If there was something gross negligence in terms of the environment, environmental protection, I think that's something that needs to be taken into account here. So I will support this amendment, and I do think it's a friendly amendment, and I hope that other members can as well. Thank you, Madam Chair.
Attorney General.
Chair, I just want to correct the record and some misinformation in case the, members of the public. So there is nothing about this that provides protection against workplace safety or gross negligence in a workplace or or the ability to get around environmental standards at all. This is strictly to do with procurement directives related to something completely different. And I don't want there to be a misunderstanding out there about that.
Just wanted to clarify my comments. In a procurement directive, where a contract was undertaken, where a company or an actor or some sort of action was taken because of that procurement directive, just want to make sure that we're not providing immunity if gross negligence had occurred in that case. And procurement directives certainly can be include procurement contracts, include procurement actions that work is done on behalf of a Crown Corporation or a government ministry. So just wanted to make sure that protection was in place. But I'll take, we maybe have a difference of opinion on how that will be read into the record.
Are there no further questions? Shall the amendment pass?
Division.
Division has been called. Is there agreement to waive time? I understand all the members are present. We can do that. All right. Disappointing. Before putting the question, I remind all members that only the members of Section C or their duly appointed substitutes are authorized to vote. The question before us is the amendment on Clause 8. Do you want me to read the whole thing? Okay, thank you. Those in favor, please rise or otherwise indicate. Thank you. Members, please be seated. Those voting nay, please rise or otherwise indicate. Thank you. You may be seated. The amendment is defeated. Oh, would you like to announce the results? Okay.
Those voting aye, Maas, McCall, L. Neufeld, Payton, and Wilson, 5. Those voting nay, Sharma, Malcolmson, Routledge, Sandhu, Wickens, Young, and Botterill, 7.
The chair apologizes for taking the clerk's second favorite part of the job away from him. Thank you. The amendment is defeated. Shall Clause 8 pass?
This is Clause 8.
Sorry. And sorry. So shall Clause 8 pass?
Oh, are you talking about the amendment? I'm standing for.
Are you standing for the question? The chair recognizes the member from Richmond Queensborough.
So I still have some concerns about Clause 8. And just going to get to my next question.
Member,
So-
could we just pause for a moment until staff has time to return? Oh, that's right. Oh. Yeah, thank you. All right. The chair recognizes the member from Richmond Queensborough.
Okay, so Clause 8, subsection 1, refers to no legal proceeding for damages. How would that work in practice, like that protection? How would it work in practice? Normally, somebody would, say, serve a demand letter first, and then in a legal action, just to kind of engage the other party. And then the next step would probably be to file a notice of civil claim. How would this process work? How would this protection come about?
Attorney General.
So there's a lot of different ways that this could show up operationally. So it's an immunity provision. So what happens then is if the defendant there's a defendant in action has been served by a demand letter or a notice of claim, they would, I'm sure, at the very quickly contact the province and say, if it's a demand letter or a notice of civil claim, hey, like this, because of this clause, there's no action against me. So then, through that discussion, likely what would happen is the province would, they could bring forward an application to dismiss the claim against them, right? So they would have the provincial help and support in doing that. So it would end the claim against them. And then the province would have a suit against them. They would likely be the party that would be the one to take on the claim.
Member for Richmond Queensborough.
So is my understanding correct? The province would get involved at the stage where the notice of civil claim is filed, not at the time when a demand letter is informally served.
Attorney General.
Yeah, so I mean, you could see a possibility where government procurement entity served a demand letter and contacts the province, right? And then we're engaged with them in a way at that time. So, but then, there's so many scenarios there. If you put that into because a demand letter doesn't necessarily mean a claim, an actual claim, unless they filed it, right? So there's a whole range of possibilities there. But in effect, what the provision does is to say, if it's related to, as we talked about in detail, related to this person's or this entity's enactment of a procurement directive, then the province will step in.
Just take a step forward. When the matter gets to, say, the Supreme Court and there's a notice of civil claim that's filed and a government procurement entity is sued, does the province get involved in terms of filing the response to a civil claim and then also enumerating a defense saying that, well, you are barred, you are statute barred pursuant to Section 8, subsection 1 of this particular act? How does that work?
Attorney General.
Yeah, so the beginning thing to say is that depends on the facts of the case. So if the province gets involved or not, and I think we talked in detail about the way this is meant to be applied and where we would step in. And then the other answer is it depends, because in effect, what would happen is like this provision has to be read with the next clause that relates to indemnity. So in the situation, the government procurement entity that is facing a legal proceeding for damages through Section 8, and working with likely the provincial government could make an application to strike, saying there's no action here. But there could be scenarios where you were likely to be named as well in some of those. So then you could see an agreement where the province says, we'll defend everybody. Or you could see an agreement that might show up that says, we'll pay for your legal fees to defend this. So there's the 8 and 9 working together mean that there could be many different scenarios about how they show up, and it would all be in working with the government procurement entity.
Member for Richmond Queensborough.
So, going back to the stage of the demand letter and then the notice of civil claim, I understand the next section deals with immunity and, I believe that's indemnification. Yeah, that's indemnification. And, but going back to here, I understand somebody being indemnified, but sometimes there's no money to be indemnified for. It's just a nuisance. And it takes away from maybe some government entity was doing other work and was given the inconvenience. Under this section, is there any protection under this section that the province would just take away that headache?
Attorney General.
That answer is in clause 9. So when we get to that, I could point to the provisions that talk about covering those things.
Member for Richmond Queensborough.
So, in terms of Clause 8, what we know so far is the government's interpretation. It's very broad, to provide a broad protection. And and we had some discussion on consultation. I brought up the point of consultation, and the Attorney General mentioned that we had a general discussion on consultation involving the bill as a whole. And then we had some further discussion about this particular section. So in terms of this particular provision here in Clause 8, it talks about no legal proceedings to be taken against someone if they're complying with a directive, and to the exception of, say, if they did bad faith. Are there examples are there precedents in other acts or other areas that the government's involved in that they have similar, exact same provisions such as this one?
Attorney General.
So I'm told that this is very common, so we can pull an example up, but you would see provisions like this obviously adapted to the particular scenario, but it's very standard and included in many pieces of legislation.
Can the Attorney General please provide an example? So maybe a couple examples, so we on this side of the House, we can actually look at those examples and understand this piece of legislation better?
Attorney General.
So when we did a search over here on the term no legal proceeding, we got 85 hits in legislation, so it's a very commonly used term and it points to that provision. An example that I could give is the Transport Investment Act, Section 8, 3.1, but we can pull up many more if needed.
Call the committee back to order. Bill 7, Economic Stabilization Tariff Response Act. We are on Clause 8. Shall Clause 8 pass? The chair recognizes the member from Richmond, Queensborough.
So I just want to, I have a hypothetical situation that came to mind. If the Attorney General or a minister identified a contract that they no longer wanted to honor, and then use this section to force a government procurement entity to cancel that contract, would there be any legal implications of that in terms of like the government telling the procurement entity? Would there be any consequences for the government? Have they contemplated that? Has the government received any legal advice to that effect?
Attorney General.
In that scenario, if we used, it wouldn't be this clause that we would use because this clause doesn't give us the power to do anything as described, but in a scenario where government directed with whether procurement or not, through a directive or not, if they've just directed an entity to say you have to break a contract, there would be any types of liability associated with depending on that contractual breach. This section doesn't in any way avoid liability or any legal consequences of actions that might incur liability. What it does is it shifts it away from a government procurement entity as long as they're doing the conduct as described.
Member for Richmond, Queensborough.
On a different related topic on the same clause, has this government, has Attorney General's Department assessed the potential economic and reputational consequences of shielding protected persons under this particular clause? Has there been some sort of assessment done? What could be some consequences of doing that?
Attorney General.
So there will be no assessment right now because there's no actual procurement directive under the Act in place. And if you remember the discussion from Clause 7, you'd be able to design that procurement directive at the time of its issuance to understand things like that. And I think they would be designed, as we talked about in detail in Clause 7, in a way to make sure that viability was a part of the risk assessment.
On this clause, but on a different issue, what measures has the government put in place to ensure internal accountability and whistleblower protections are not undermined by this provision?
Attorney General.
I have answered this question before, and the reason I know that is because the expert in government on whistleblower legislation is sitting beside me, and I think I already talked about that, where we have some of the strongest whistleblower protections in government, and none of this would impact that.
I do recall that there was a discussion on whistleblower, but I don't believe it was on Clause 8. I believe it was on a previous clause that we were reviewing. So the questions to this particular clause.
Nothing here displaces that, and if the member has a specific question of how anything here would relate to whistleblower legislation, maybe I can answer differently.
Okay, and I think this might be my last question on Clause 8. So now, obviously, the government's had some time to think about this legislation and come up with this legislation, particularly come up with this particular clause. How does the government believe that this clause strikes the right balance between protecting public servants and ensuring the public has a means to hold officials accountable when procurement decisions lead to harm?
Attorney General.
As I answered previously, there's nothing in here that avoids liability if there's a potential for liability to be found. It just shifts it away from the government reporting entity to the province.
Shall Clause 8 pass? Aye. So ordered. Shall Clause 9 pass? Aye. The chair recognizes the member for Prince George Mackenzie.
Thank you, Madam Chair. So moving into Clause 9 here. As we've talked about, it's been said several times now, Clause 8 and 9 work together, so we'll get into a little bit more of that. But I want to just start by asking what specific types of legal proceedings that are covered under this indemnification, just to make sure that we're clear. Does this include all civil and criminal matters in Canadian courts, or any other matters in Canadian courts?
Attorney General.
Thanks. So Section 8 and 9 are to be read together, as we've talked about before. The reason for the Clause 9 is to indemnify the protected person for the costs and expenses related to anything that happened in Section 8. And so that's the reason for this clause.
Member for Prince George Mackenzie.
So would that include both civil and criminal matters in indemnification then?
Attorney General.
Civil.
Member.
What about, since this is also in the context of a trade war, so what about international arbitration or foreign courts? Obviously, we're talking about procurement directives that are to do with international trade. I think this example could be quite plausible. So what about foreign courts? What about things like the World Trade Organization, other bodies that would be judicial or otherwise in nature?
Attorney General.
Yeah, so the nature of the type of dispute resolution that the member is talking about is government to government. So a lot of those breaches of international trade, Canada takes the suits, or the states does on behalf of the nation state. So it wouldn't, and then other part of that is there's no damage claims. So that, we remember in Clause 8, it says legal proceedings for damages. For those reasons, then this would, those kind of disputes probably wouldn't be covered.
Has that been tested with the federal government at all? If they probably wouldn't be covered, so just I'm wondering if there's any interaction with federal, I'm not actually sure which ministry that would be, but maybe from a legal perspective, you might know from for where that might end up, and perhaps maybe the international trade, for example, they would have that clarification, but just wondering if that would be has been tested at all.
Attorney General.
So the way that this would show up in line with the members' questions is that the definition of protected person, so we went through that as a government protected procurement entity, and that wouldn't be and can't be a party to any of those disputes, the international trade disputes or mechanisms. So that wouldn't happen. Now, remember that none of these provisions are about like ending liability, so shifting the liability away from the government reporting entities. So we would take that on anything, and they wouldn't be able to be a party to any of those disputes.
Recognizing the member for Prince George Mackenzie.
Welcome to the chair. And through you, Madam Chair, thank you to the Attorney General for the response. Just again, this is in the context of a trade war that's going on. So has the ministry considered how foreign governments or trade partners might actually view the indemnification clause, really, particularly if it applies to any actions against a foreign business in British Columbia that's doing business in British Columbia?
Recognizing the Attorney General.
Thank you, Chair. So again, it doesn't change if there's a possibility of any action that foreign entity might have against the government. But this is about the relationship between the province and the government reporting entity, right? So in that sense, if we're stepping in instead and protecting the government procurement entity, so in the scenario provided, if there are actions that could be taken related to this, or if somebody wants to try in the context of a trade war, the courts are a process for that. And there's nothing about this legislation that would, it doesn't close off the potential for liability, it just shifts it.
Recognizing the member.
Thank you, Madam Chair. Maybe I'll just move back up to maybe understanding how the indemnification process works overall. So what process would be in place for a protected person to apply for indemnification in the first place?
Recognizing the minister.
Thanks. So we have to remember that Clause 9 only comes in to play after Clause 8. So we've already been in contact and in relationship with this government procurement entity that has a legal proceeding against them for damages, right? We've already stepped in somehow, and that immunity provision in Clause 9 is at play. This is about the costs or expenses that are related to that, and we're indemnifying them. So in that situation, in a relationship would already have existed. So it wouldn't be like an application process or something. It would be part of the process of dealing with that legal proceeding.
Recognizing the member.
Okay, because so, just so I understand this correctly, so immunity's already been established, so the indemnification is automatic, is that correct?
Recognizing the minister.
Thanks. So yeah, the immunity's already kicked in, and this would be the section that helps to fill in the gaps of like costs or expensive that have been incurred by that individual. So yes, it's already at play.
Recognizing the member.
Thank you, Madam Chair. I'm wondering if the Attorney General specifically or Cabinet as a whole have any specific powers around the indemnification for decision-making authority that need to be, I guess, clear in this. If the Attorney General can provide that, that'd be helpful.
Recognizing the minister.
So there would not be a cabinet role for this, but I can talk through how we have a lot of situations where indemnities are kicked in government. And the process for that is a risk management that's situated under finance that does a risk assessment of that and would assess whether or not bad faith was implicated or if we think that we should play a role. And then any litigation decisions or how we act in litigation then switches over to the AG. So that's under my ministry.
Recognizing the member.
Thank you, Madam Chair. Maybe just on following up on the Attorney General's response there, how will government ensure that the indemnification is, if it was to be denied on a bad faith exclusion based on the example provided, how would the government ensure it's denied appropriately when there's some sort of evidence of bad faith?
Recognizing the minister.
Okay, so it would obviously depend on the fact of the case, but the processes that I talked about at the previous question would assess whether or not they determine there's bad faith on the facts of what's presented to them. And in that case, if the GPE wants to challenge that, and of course they can challenge that decision, that's saying that they didn't show bad faith, and that would be a court determination then about whether or not that was at play or not. And then if it's a situation where there's lack of clarity, whether or not there was bad faith, and we've done our internal risk assessment and we've decided it's unclear, we don't know, but during the legal proceedings, stuff comes up that would tend to show bad faith, and it gives us the ability at that point, upon a court determination, to also kick in these provisions.
Recognizing the member.
Okay, maybe I'm just need a little bit more help understanding the Attorney General Ministry's role in determining, I guess, who makes the determination of bad faith and when, especially if it is to be denied to an entity for a reason. So just hoping to get a little bit more help with that. Maybe you could explain it again in plain language.
Recognizing the minister.
Yeah, so as we talked about, there's a risk management branch of the Ministry of Finance, and they deal with, they're in the internal structure that deal with indemnities that exist within government or provisions similar to this. They, with the help of LSB, which is under my ministry, so the Legal Services Branch, that's full of the team of lawyers of government, would help make that determination of whether or not there's bad faith up front to the point that the decision be made not to pursue it, or to, if there's doubt, indemnify unless a court determines bad faith through proceedings. So that's kind of the internal process of how it works right now, and this would be part of that.
Recognizing the member.
Thank you, Madam Chair, and appreciate the response from the Attorney General. I guess that is helpful to understand the current process. So would that same Ministry of Finance process kick in for, I'm wondering if there would be a limit or a cap on the indemnification amounts that were actually could be provided in any of these cases?
Recognizing the minister.
Yeah, so in this provision, the limitation is based on it only being costs or expenses. So it's capped in the sense of what the categories are in a proceeding. So costs are pretty well understood in a legal proceeding, or expenses related to that, so.
Recognizing the member.
Thank you. I guess on that same kind of vein, are there any limits to this indemnity in terms of the financial or to the time frame of it, I guess, so how long it actually applies for?
Recognizing the minister.
Okay, thanks. There's a few answers to this. So first of all, general limitations, periods, and Limitation Act applies. So that sets out the timing that you can have before you, when something occurs, before you can take an action. So you time out at some point. The other thing to remember about this one is it's costs and expenses, and 8 and 9 are to be read together. So it's related to that legal proceeding that was triggered. So, I mean, that means the life of that legal proceeding is what is part of it. So costs and expenses occurred as a result of that. So depending on how long that takes. And then the ultimate thing to provide with this indemnity is in section 29 and clause 29, and I'm happy to speak about that when we get to it.
Recognizing the member.
Maybe just because this specific bill we'll get to it in this, I guess clause 29, if I don't remember if that's the sunset clause one, but so maybe we'll get to that point. So okay, maybe my question as I'm talking through, I understand what the Attorney General is saying there, so I'm going to move on to my next question. I guess part of the reason I'm asking these questions is obviously just protection of taxpayer dollars and making sure that this is being used appropriately. And indemnification can be, in the government context, it can be highly political, it can be very visible. These are things that get brought up in the legislature, in the chambers from time to time under various governments over the past decades. So indemnification can be a very politically charged topic at times. So with that, will there be any reporting or transparency mechanisms when indemnification is provided under this clause? So, for example, could that include something like annual reporting to the legislature?
Recognizing the minister.
So the way that shows up as a public report is through public accounts, where we publicly account when indemnities have been used.
Recognizing the member.
Thank you, Madam Chair. That's excellent. Thanks to the Attorney General for clarifying that's where this would be found. I'll move along, and I certainly don't want to open up the debate on the question of gross negligence again, so I'm going to spare the Attorney General further discussion on that topic. But I do want to get into just a little bit of understanding of what safeguards might exist to ensure this indemnification is not used to shield negligent or reckless conduct overall.
Recognizing the minister.
It's going to be the same answer as I did for clause 8, but bad faith has the same meaning as I talked about, including recklessness and gross negligence, and it's a legally defined term.
Recognizing the member.
Thank you, Madam Chair. I recognize that. I recall the Attorney General's response in that regard, but I'm wondering what safeguards exist to ensure that the indemnification is not used to shield negligent or reckless conduct.
Recognizing the minister.
So that answer is in subsection 2, and that it says pretty clearly that we can't use subsection 1 or identify anybody for bad faith.
Recognizing the member.
Thank you, Madam Chair, and maybe I appreciate the answer. I'd asked the same question, one that's not spelled out as specifically, the same question about safeguards to ensure that this indemnification is not being used for purely, political purposes to shield for political reasons, or even worse, for corrupt practices. I know another member has talked about, use the example in the federal government context of the sponsorship scandal that happened, but if corruption did occur, what safeguards are in place to make sure that we're not shielding someone or an entity based on those kind of terms?
Recognizing the minister.
So the first thing to keep in mind is that as section or clause 8 and 9 are to be read together, and that I described the purpose of clause 9 before as an ability to recover costs and expenses related to legal proceedings. So 8 and 9 are together. So all of the safeguards that I mentioned under 8 would apply to clause 9 as they're to be read together, and this is actually just to fill the gaps of costs and expenses related to 8. So there's nothing that in any of these provisions that shield people from, or shield government from liability. It just shifts liability. It says to the government reporting entity, if you do things, not if it's bad faith, because we're not going to protect you then, but if you do things that we told you to do under the procurement directive and do so, and there's any legal proceeding for damage related to that, we're going to step in. It doesn't mean the legal proceeding ends. It doesn't mean the liability that could be placed on the province is ended. So, and it doesn't mean any of the other laws related to corruption, all the kind of bad scenarios that have been talked about in questioning, that we can avoid liability for that. This just shifts it from the government reporting entity to the province, except for bad faith. So a lot of the things of the scenarios that are being described are pretty squarely in that category of bad faith.
Recognizing the member.
Thank you to the chair. Appreciate the response. I guess just to make sure I'm clear, so this clause would not allow indemnification in cases where a person knowingly violated any other provincial or federal laws while acting under this act.
Recognizing the minister.
That's correct. If you're knowingly doing something like that, it is clearly bad faith.
Recognizing the member.
Maybe just wrapping up my comments before I pass on to the Attorney General critic. Maybe just wondering if the Attorney General could just provide a bit more general context on how this indemnification interacts with the other existing public sector indemnity policies. We've talked on it a little bit, but I wouldn't mind a little bit more fulsome context than that.
Recognizing the minister.
Thanks. So yeah, government procurement entities may have their own indemnity policies, and there may be procedures, as the member asked about. But the reason for this inclusion is we're asking them to do something that's potentially outside of their policies or their indemnity coverage, and we don't know that for sure because there may be a range of them out there. So what this does is provide clarity and consistency with respect to any procurement directive. So what that means is that we're telling them that if you are doing something, and as a result, because of these procurement directives, and as a result of that, there's some legal proceeding against you, then we are going to indemnify you in these ways. So it's very clear. And that way, despite whether or not individual and indemnity provisions do or don't cover what we're asking them to, which may be unusual for them, it will be covered. So,
Recognizing the member for Richmond Queensborough.
Welcome to the chair. And I want to thank the Attorney General once again for answering my colleagues' questions. And the answers are much appreciated. Thank you. And so I would like to go to Clause 9, to the terminology of Clause 9. The clause reads, subject to subsection 2, the government must identify a protected person for any cost or expenses incurred by the protected person in any legal proceedings taken against a protected person for anything done or omitted in complying with or intending to comply with a directive issued under this part. Now, the first part that I need some clarification on is the word must. So the government must identify. From the sounds of it, there seems to be no discretion in that word. So is it automatic if there's cost, expenses suffered by a government procurement entity due to some sort of legal action, is the government obligated as soon as they find out about that situation? Because this language states must.
Recognizing the minister.
yes.
Recognizing the member.
I thank the Attorney General for that clarification. And so then going further, it says must identify a protected person. Protected person, I would take it that's the same explanation I was provided for protected person. And the concerns I had, the same explanations would come about from Clause 8. Those explanations, they would apply to this Clause 9 as well. Is that?
Recognizing the minister.
Yes, it's the same definition of protected persons.
Recognizing the member.
Okay. And then going further to where it's stated for any costs or expenses. Now, I have a bit of an issue there. The issue there is that sometimes the law distinguishes between reasonable expenses and unreasonable expenses. And some people may incur extra expenses knowing that they're going to be reimbursed for it. So what is the Attorney General's perspective in this terminology for any cost or expenses? Is the Attorney General, with this legislation, stating even if there's unreasonable costs and expenses, the government will still be liable for them?
Recognizing the minister.
Thanks. So reading the clause as a whole, it's a very common term that's used in many pieces of legislation related to this. The important words to rely upon when you're understanding what kind of costs would be included or not is any costs or expenses incurred. So it has to be something that a person has paid out of their pocket by the protected persons, so by the protected persons in any legal proceeding. So it's limited in the context of the clause itself to make sure that it's costs that were related to the legal proceeding that they've incurred.
Recognizing the member.
Thank you for the explanation. I'm aware that the Attorney General has much legal experience as a lawyer as well, as do I. But when there's legal actions that happen, there's times to when certain lawyers, on behalf of their clients, they order expert reports. And when expert reports are ordered, sometimes those expert reports are found to be unreasonable. And sometimes the courts disallow certain reports for not being reasonable. So the question goes to here, I understand the legislation, but what if a particular government procurement entity was a little bit extra aggressive in incurring expenses? Would they get relief in this section still?
Recognizing the minister.
So it's important to remember the context of Section 9 when it occurs. So Section 8 says there is no legal proceeding against that defendant. And then we talked in the last section about how there'd likely be a dismissal application or something that drops it against that defendant. So we wouldn't have a scenario where, as the member describes, the government procurement entity has a vigorous thing where they're incurring expenses with experts because there's no action against them as a result of Clause 8. So then the province would then likely take over conduct or be sued directly. So we are talking about the costs and expenses that occurred in between the time that defendant was part of the legal proceeding and the discussions with the province about what they're doing about it, and it be dismissed against them. So it's very limited in its application or its a scope, and it's to provide insurance to the government procurement entities that we have their back as they're doing this. And then the other thing would be is that I think we talked about it a lot about the risk management branch that's in finance, and they exist to process these identifications. So they would be in communication with that entity that it's being triggered by that legal proceeding to control costs and understand costs. So there's that operational side of it as well.
Recognizing the member.
The Attorney General would agree with me, although that the action might be limited in scope. There most likely probably will be some disbursements, correct?
Recognizing the minister.
Yeah, I mean, it would depend on the, yeah, it depend on the action and where it comes. Like, I think there's a scenario where it's a demand letter. We talked about that before, where that triggers the province stepping in. So it really depends on what state they're at. But like maybe there's like a printing thing, maybe there's a cost of, yeah. So there may be some cost, and that's why we have this section.
Recognizing the member.
I understand that there was some discussion about the government department that handles these types of claims. And I understand this section. But the issue here is that the person that's going to want to claim reimbursement, if the government department says, oh, this expense is a little bit unreasonable, that person is going to come back to the section and say, well, hey, no, you can't discount my claim because I have this section to protect me. So, government, you are obligated to pay me. Is that not the case?
Recognizing the minister.
So how that would play out is that if there is, so again, if it's a cost or expense that is incurred by the person in a legal proceeding, and they say you must pay it, and we dispute that and say we don't agree that this is a cost or expense that was incurred in the legal proceeding, or there's some aspect of that, we would make that determination, and then it would be a matter of legislative dispute about whether or not that section applies, and they could review us in court if they disagree.
Recognizing the member.
So if my understanding is correct from that explanation, the party that feels aggrieved, I guess, by the government for not paying pursuant to this, that party could have a action against the government to claim the excess expenses that the government found unreasonable, correct?
Recognizing the minister.
Well, I think what the member is describing is a hypothetical situation. What I was trying to say that in the event of the fact that we say that this is a cost that is or expense that wasn't incurred by you in the legal proceeding, and the protected person disagrees with that finding, then there is a ability for them to say, you know, I'm going to review that in court because I don't agree with that finding. Again, we're talking about probably not likely very high expenses, so I can't imagine that happening, but that would be the avenue.
Recognizing the member.
There may be also a situation where the government procurement entity does not provide notice to the government of a legal action in a timely manner. They might just proceed forward with that legal action, defend themselves, and provide notice to the government at a later date. Isn't that a plausible explanation? Isn't that a plausible situation as well?
Recognizing the minister.
Yeah, thanks, Chair. So we're having a really hard time imagining the scenario that the member provided us because they are government reporting entities. So they're so closely tied to government and our relationship with government that there would be a few failures that would happen for that for that instance to happen where a lawsuit has continued for a long time and we don't know about it. There would be a few failures that would happen that are probably zero chance of happening. And one is that we weren't also named in that lawsuit, which very, very unlikely. Two, that an entity like the Health Authority or ICBC or BC Hydro, the government reporting agencies that we're talking about, aren't sophisticated enough to understand indemnity provisions and how they can avail themselves of those indemnity provisions and have incurred expenses without doing that. And I would say that would also be very highly unlikely. And also, just in the nature of the relationship we have with the ministries and the way they interact, I think that would be inconceivable. Also, as Attorney General and in our office, I would likely get notice of major litigation related to procurements or things like that. So I think this scenario is very unlikely. In the situation that it would happen, barring all of those things, that making all of those things just fail, then it would go back to the provision, and if they notified us at some point saying that actually clause 8 and 9 should have applied to this proceeding and we've gone this way far down it and haven't told you about it. So then it would be a matter of us figuring out how Section 9 applies according to the wording of it. And of course, like, costs are something that are assessed by a judge, so that's part of the process. But then we would have to sit down with them and take a look at how far they went and how these indemnity provisions apply to that.
Recognizing the member.
Just adding to the last point, the damages or the expenses would be assessed by a judge. Is Attorney General saying that the government would only pay the damages that were assessed by a judge, or it doesn't really matter if it was assessed by a judge?
Recognizing the minister.
Thanks. I said the costs were assessed by a judge in a legal proceeding, and the expenses, obviously that's a different category, but in a proceeding, it's a cost that you get the judge to assess.
Recognizing the member.
But there may be a situation where all the expenses are not awarded under the bill of costs. And so in that situation, would the government pay all those expenses regardless of them not being awarded?
Recognizing the minister.
So the clause talks about costs and expenses related to the legal proceeding, so it's not damages, right? It's not any claim of damages or those things associated with that. So And then I would just go back to the conversation that I had about we had about the risk management branch and how these indemnity provisions kick in and how there's a whole fiscal and risk management process that happens with the party at that stage. And if there's any dispute on that, they can challenge it.
Recognizing the member.
Yeah, I was not referring to damages, just for clarification. I was referring to expenses. So bill of costs includes what units you can get under court rules for costs, and then also expenses, which are referred to as disbursements in court actions under a bill of costs. So expenses, that's what I was getting at for clarification purposes. I have an unrelated question to Clause 9. Well, I guess it's kind of related. It has to do with lawsuits. Is the government actually expecting many lawsuits due to this legislation?
Recognizing the minister.
So there are no procurement directives issued, so that's the first thing. I think I would say no, because I talked a lot when we were talking about Clause 7 related to how the procurement directives will be designed and the ability for there to be an assessment of viability and risk assessment of the government reporting procurement entities. So, but these provisions give the assurance to our partners that we want to work together on this.
Recognizing the member.
In the event there were lawsuits, maybe there was some sort of risk assessment done. That's why there's some provisions in here to address risk. What could be the estimated value of lawsuits as a result of breaches in contracts or obligations that government procurement entities may have, but they don't go forward with those provisions and because of government directives, and instead they rely on this section? What could be the extent of the amounts that could be potentially awarded in regards to those lawsuits?
Recognizing the minister.
Thank you. So again, there's no procurement directives that are have been issued at this stage, and there's no viewpoint now, at least for myself or the government, that we would be issuing procurement directives that would be directed at incurring tons of liability. They can be designed in a way that minimizes that, and they will be. So no such risk assessment or analysis as it has been done, because at this stage, the analysis and the thinking behind these provisions were about designing an enabling statute that contemplated all the ways that we could make sure that we had clear, consistent, and the powers to issue these such directives to our government procurement entities.
Recognizing the member.
Is there any precedent that the government has where they've used similar legislative provisions, such as Section 9, to deal with maybe not procurement, but maybe another area that involves huge amount of money, and certain entities performing certain obligations in regards to the money that's kind of connected to government services? Is there some sort of precedent that shows that there's a indemnification of provisions, and is there something like that, first of all? And then secondly, what has been, if so, what has been those expenses related to lawsuits in similar situations?
Recognizing the minister.
Yeah, so I think it would be really, it would be really hard and unhelpful to compare, because we were talking about other enactments that include indemnity and similar provisions to this, but they're so entirely different than, like, one is the Auditor General's Act, one is the Civil Resolution Tribunal Act. Like, they're so situated in their context that comparisons between them really wouldn't make any sense.
Members, we will take a short recess, a 5-minute recess at this time. If we could please return back to begin at 7:36. Thank you. Calling section C, we're on Bill 7, back to order. We're on clause 9, recognizing the member for Richmond, Queensborough.
Just before we had the break, I was about to ask a question related to the answer that was supplied by the Attorney General. The questions and answer had to do with lawsuits, and the Attorney General was providing explanation why the current precedents would not be applicable in this case because they are so diverse. But my response to that, I would still like to know, even if there's like a wide range, because that would help me understand and would help our caucus on our side understand what is the extent, what's the low end, what could be the potential high end. Although it might not be exactly applicable to this situation, at least we would know, well, this is the low end, this is the high end, and maybe somewhere in between, maybe these lawsuits related to procurement that connect to Section 9 might be, the subject matter might be in between there somewhere. It'll still give us some sort of benchmark rather than zero or nothing at all. Like otherwise we have no clue.
Recognizing the minister.
Yeah, so it's just not information that I would say, first of all, it's irrelevant because of the reasons that I talked about, the different regimes being so different, and it's just not information I have, nor do I think it's relevant to the clause. So I'm just going to have to go back to the fact that I think that we don't have any precedents related to procurement and indemnity in government. And any other provisions we have in the many, many statutes that exist may or may not be used, and there's no analysis that I have to offer here, nor do I think it's relevant.
Recognizing the member.
With all due respect, I do feel it's relevant because that's information we need to know. If lawsuits are going to come, obviously lawsuits happen in everyday life in British Columbia. It's just a fact of the matter. They happen, and when there's bigger amounts of money involved and there's more transactions, they happen more often. That's just a fact of the matter. So there are concerns if we do not know, we don't have any sort of precedent on this side of the house, and we don't know the extent of the consequences that could lead as a result of having this provision. That's some critical piece of information that would help us understand and and also educate the public. So a follow-up to that particular question, although we cannot receive information in regards to precedents from the Attorney General's Department, a follow-up would be, has the government put aside a reserve to deal with the lawsuits that may come about? For example, they may be like, just an analogy, insurance companies. They set aside a reserve that they might have certain claims that may happen in advance. And has the government done such a risk assessment and said that, look, we are going to put aside a set number of dollars because we might have some court actions coming our way, or we might have to reimburse some government procurement entities. Has the government done that action? Has the government put aside funds, first of all? And secondly, if so, what funds have been put aside?
Recognizing the minister.
Yeah, so there is no reserve, and I just want to keep in mind the member, this is an enabling piece of legislation. So as an enabling piece of legislation, it gives the government power to issue a directive. So at this point, whatever that directive is and who it applies to and the scope of it and all of those things associated with it would be in the hands of that minister once they issue that procurement directive. So, and any analysis of liability just isn't like, I wouldn't be able to do that on anything based on no actual directive at this stage. But what I would say is that, generally speaking, how it works when it comes to the Ministry of Attorney General and the way things would happen with litigation. We don't set aside, there's not a pocket of money, it's like would be contingencies in the government that would be there for that.
Recognizing the member.
So going to that last phrase that was just mentioned, contingencies, what does the Attorney General mean about contingencies?
Recognizing the minister.
So it's the way we budget in government, right? You set your budget and you set aside your operating expenses, and then you put in a portion of money for contingencies that are related to how you deal with unexpected things. So that's just a budgeting process of the government, and that's how it works.
Recognizing the member for Kelowna Mission.
Thank you, Madam Chair. Can the Attorney General expand on the estimated potential extent of risk exposure that is covered by those contingencies?
Recognizing the minister.
Yeah, I think I already answered that. Like, this is not there is no procurement directive right now. And we've talked for days about how the procurement directives would show up, how we'd be working with the government procurement entities, all the procedures and steps that would be put in place to do that. So I've answered that.
I would respectfully disagree. I don't think the question is around what the Attorney General has just asked. What I'm trying to understand is what the extent of potential risk exposure is. So has there been analysis undertaken about the extent? Obviously, there's not a budget relative to this risk. You've talked about contingency. I want to understand both what the maximum potential financial exposure is and the probability of that risk is, so that we as legislators can understand what, on a risk-adjusted basis, the total financial exposure is estimated to be. And if that work has not been undertaken, I'd like to understand why it hasn't been.
Recognizing the minister.
Okay, so I've answered this many times, and I'll explain again. There is no procurement directive right now. This is an enabling piece of legislation. It enables ministers and ministries to issue procurement directives. At the time of issuance of a procurement directive is the time that the minister with that government procurement entity and wherever it would apply, would assess risk, would assess all of the things that the member is asking about. There's nothing to attach a risk assessment to at this point. It is an enabling piece of legislation that enables ministers to issue procurement directives. In the context of making a procurement directive is when you would do the analysis that the member is talking about, and when you would build in wording in that procurement directive to mitigate risk, to mitigate litigation, to make sure it's clear with that procurement entity what you're asking them to do.
Recognizing the member.
Thank you. I'm a little confused and frustrated here. It's April 30th. This has been ongoing for some time. And what I'm hearing is that no work has been done to evaluate the potential risk and exposure as a result of government indemnifying protected persons. While I recognize that there may be individual scopes of risk, there may be individual levels of exposure that are consequential to any given specific individual procurement decision, I do think it's really very material at this stage that we as legislators who are being asked to move forward with a bill in which the government is going to indemnify individuals for costs or expenses. And what I'm hearing is that there has been no analysis done of what the broad scope of that risk exposure could be. That's what I'm looking to understand. I'm not looking to understand future analysis and future decisions that are made in the future. What I'm looking to understand is whether any work whatsoever has been done to understand what the total quantum of risk exposure is.
Recognizing the minister.
I'm going to ask for your guidance on this, Chair, because I have answered this many times. I will just say again, the crafting of the procurement directive and the ability of anticipating and mitigating claims when they do the directive is the way that we manage that risk. This is an enabling piece of legislation to give us the tools to do all of that.
Member, the Attorney General has indicated that she has provided a response, and although you may not be happy with the response, in my view, that this line of questioning is at risk of becoming repetitive. So I would ask that you please reframe the question or pursue another line of questioning.
Thank you. I will bring this line of questioning to an end simply in saying that I am unsatisfied with the fact that it appears no analysis has been done about the potential risk exposure to the taxpayers of British Columbia, and that I believe that the failure to do so falls well short of the diligence that we should be exercising as a legislature as we're asked to move forward with this. I would not, in good conscience, in a governance role in my prior work in the private sector, allow such a risk to be taken without it being appropriately quantified and having an understanding of what we're actually dealing with here. So I am genuinely shocked at the intransigence around this basic information. But with that said, I'll bring my questions on this to a close and hand back to my colleague.
Okay. Recognizing the member for Richmond Queensborough.
In regards to this particular clause, what threshold or evidentiary standard will be used to determine whether a protected person acted in bad faith and is therefore not entitled to indemnification and protect? I know it was explained in a previous section, but in this particular clause.
Recognizing the minister.
Just confirming that it's the same analysis of the answer that I gave on clause 8.
Recognizing the member.
In regards to this last question I asked, who will determine who will determine the threshold to the evidentiary threshold for indemnification? Like who will be the assessor in the government to say that this entity has met the threshold, now let's pay them out? Who will do that?
Recognizing the minister.
I've had the exact same line of questioning already by another member, but of the same question about, so I talked about the risk management board, I talked about how those determinations are made, and so also asked and answered.
Recognizing the member.
All right, so another question for the Attorney General. In regards to the comparison between Clause 8 and 9, Clause 8 talks about it's kind of statute bars organizations or entities from suing government procurement entities. And so based upon that logic, if nobody can actually sue these entities for obligations that they have to the government, and we had a discussion earlier about court costs. Successful party, if you can't sue a successful party, you may be awarded court costs. So in what situation, if Section 8 is applicable, does the government see Section 9 coming into play if nobody can actually sue somebody?
Recognizing the minister.
Yeah, so I think I've answered this one a few times too. So it would be the costs like that are just incurred by that party as shifting it over to the province.
Recognizing the member.
Is the government planning to implement any sort of safeguards or measures that will help mitigate the risk in terms of paying out? I know the Attorney General mentioned information about potential reserves and reserves not being there, and there being no potential precedents on what could be the extent of exposure. But has there been any sort of framework? And I also understand that the Attorney General has said that this is an enabling statute, but there has been some significant effort put into this, and in previous clauses of this particular bill, Attorney General had said that they had worked with, I believe, the ministry, the Jedi ministry, as well as maybe labor as well. So there was multiple ministries that had come and brainstormed how to bring this forward. So was there any sort of framework that was discussed to kind of say that if we're going to pay out, how do we minimize that risk?
Recognize the minister.
Yeah, thanks, Chair. I've answered this question also.
Member, I would just ask that you move on to a new line of questioning or ensure it's not repetitive. Recognizing the member.
Sure. I can move on, but I believe the questions that were answered is whether there's any sort of reserves. This specific questioning doesn't relate to whether a reserve was set aside or there are certain frameworks. The issue is essentially whether there was any work done in terms of like setting some sort of framework. So I respectfully disagree that it was answered, but I will move on to another question. Okay, so going back to, earlier I had some questions about the wording of Clause 9. So going back to the wording of Clause 9, we had finished discussing any costs or expenses, but going further, we referred to protected person, and was told that the explanation was the same as Clause 8 in regards to that, and then we also discussed legal proceedings. Going further, that brings me down to the last phrase of this subsection, which talks about complying or intending to comply with. I did take an issue to the explanations that were provided in Clause 8. And does the Attorney General have any further explanations in regards to this language? Because my position in regards to Clause 8 was the language wasn't that clear, and I felt that the language by having in complying with alone could actually address what this clause was trying to accomplish. So we had an extensive discussion on Clause 8. Now that we're on Clause 9, I ask if the Attorney General has any further explanation here.
Recognizing the minister.
No.
Recognizing the member.
I still have issues with the wording of this legislation for the reasons I supplied in Clause 8. And going further to subsection 2, the language refers to subsection 1 does not apply to a protected person in relation to anything done or admitted in bad faith. Now, I said in the previous clause that wording should have, there should be wording such as gross negligence, and the Attorney General responded and gave an explanation why it should not be there. I did not get a chance to respond to that, but I will respond to it now. When you're going back to government procurement entities understanding what their legal protections are, or what sort of consequences they may have, they have to have proper legal education or information of how these sections work. And there was a fair bit of discussion that we had earlier about that, and I let through the chair, I let the Attorney General know what my concerns were. And there is a provision, and we also discussed a provision in Clause 8 that dealt with also providing a broad-based protection to government procurement entities, although I was explained that these government procurement entities are sophisticated entities. So they understand, they have legal departments, they understand all this. So I was told that they will know how to comply. So, but when I got to the point in Clause 8 to talk about the gross negligence, I was told that it was a broad blanket. So there was some sort of, I did not agree to the explanations that were provided there. So my issue now with this particular subsection is that if it said bad faith and it also said gross negligence, it would be obviously, patently obviously apparent by looking at the section that if somebody did gross negligence, it would not be included. So although the Attorney General did mention that under their definition of bad faith, gross negligence would be included, and so there was no need to have it. But if it was included, people could clearly look at the section and say that, look, gross negligence, we better be prudent about how we exercise our due diligence here, otherwise we might be liable. That could actually be a safeguard here. And I'm of that same perspective, and I wasn't clear enough that, because I didn't get a chance to respond to the Attorney General after she gave her explanation. So I'm explaining it now. If the wording is there, gross negligence, although it may be included in bad faith if you do the legal interpretation of it, But if it's outside as well, if it says gross negligence, that would be very obvious to a government procurement entity that they need to exercise prudence. So, does the Attorney General have any further explanation after hearing what my response is there?
Recognizing the minister.
Nothing further, Chair.
Okay, recognizing the member.
Well, for the same reasons that I had earlier, I have my reservations about this wording and what it should include. And we are talking about millions of dollars here. The Attorney General explained earlier part of this legislation that we were discussing that procurement directives may involve up to $600 million. That's a lot of money, especially in the political climate of a huge deficit that this province is facing. So extra safeguards need to be in place, and government procurement entities need to be able to easily understand this legislation. So for that reason, I am proposing, I'm moving another amendment, but amendment on this particular clause now. And in that proposed amendment, I propose to do two things. One is in this particular section, I had an issue related to costs, and I said that there's ambiguity there. So what this proposed amendment to clause 6 would actually do, it would delete the text that states any before cost, and it would also delete a part of it that refers to expenses. So it would actually, and it would actually add the words costs on a party and party basis. So for example, in a court proceeding, if somebody wasn't entitled to sue someone and the court found that somebody brought a frivolous action, they would get party-to-party costs. So that would give some sort of protection that unreasonable expenses were not being awarded, or there would be some protection to the public purse. So I feel that amendment is necessary. I did have some reservations on that wording earlier. And the other thing that this actually proposes to do in this particular amendment, it would add the words gross negligence after bad faith. And I have a copy of this that I'd like to pass up.
Anybody have the Jeopardy theme on their phone? Yeah, just keep it. Yeah. Maybe some elevator music. You can just sing. No, I don't want to get no context. I tried not singing and I get up on there.
Thank you. We will take a short recess to review and distribute, if necessary, the amendment. I call the Committee of the Whole on Bill 7 back to order. Members, we have an amendment to Clause 8. The amendment is in order. On the amendment, on Clause 9, that is correct. On the amendment, recognizing the member for Richmond Queensborough.
So I've moved this amendment, as I mentioned earlier. BC is in pretty dire straits in terms of the financial situation, and accountability at all levels is very much needed, and we need to protect taxpayers' money. And so whatever better oversight we could have on this bill, because this, as we have heard, this bill is very broad. And as we have heard in terms of even the past clause and this clause, language is pretty broad. And and we have also heard that there haven't been fund reserves set aside to deal with future potential lawsuits. We've also heard that there hasn't been a framework put together in terms of safeguards and in regards to future claims. So there's been, and then the language on this has similar language to the previous clause, Clause 8, and in this, in proposing this particular amendment, it would really mitigate risk to the funds of public tax, to the funds of BC taxpayers. So it's a really, there are minor changes in terms of wording to this particular amendment. Most of the amendment, most of the original clause would stay intact. And we talked a little bit about party-to-party costs. We talked about disbursements. We talked about costs and units in court. And we talked about unreasonable costs. We talked about reasonable costs and expenses. So this, the first change in this proposed amendment would limit the language in terms of which expenses would be applicable by awarding, allowing costs on a party and party basis. There would be a checks and balances there, because the courts would look at what's reasonable, what's unreasonable in terms of assessing disbursements. So that would help and safeguard public funds. And that's why I feel that that is a crucial safeguard in that circumstance. Further, going further, we had a discussion on the previous clause about bad faith and also gross negligence. Gross negligence could be to a certain level that it could involve a element of culpability in terms of a government procurement entity knowing that things are just not right. It's not quite right to make a particular decision in terms of procurement of goods, but they may decide to do it anyways out of gross negligent behavior. I am aware from the previous discussion from Clause 8 that the Attorney General is saying, well, the definition of bad faith. Also, there's some legal interpretation that can include gross negligence. But here, the reason why I put forward this proposed amendment to add the words "or gross negligence" is because there was also a discussion in the previous clause where we talked about knowledge of legal protections, knowledge of legal consequences, and there was some ambiguity to how the government procurement entities would understand those legal provisions that either protect them or have consequences. So by adding the words gross negligence, although maybe somewhere there may be gross negligence may be included in bad faith, but openly on this provision, having the words gross negligence will show to whoever's reviewing this on the face that if they have any sort of negligent behavior that's gross negligence, they may not get compensation. So they got to be they got to exercise some due diligence because government funds are on the line. BC has the largest deficit in BC's history in terms of finances in this province. This would show show the public, instill confidence from the public that, look, this is a broad-based piece of legislation. By having words gross negligence, it gives notice to government procurement entities that if they are not prudent and they do not exercise due diligence, there may be consequences for them, and that will give assurances to the public that public funds will be protected. So this provides, this mitigates risk in terms of what risk may be applicable to public funds in this province. So I urge the entire House on both sides of this House to support this bill because the intent behind it is to protect public funds. And people on the other side may like wave their head like side to side that they don't agree with what I'm saying. But the intention on this particular clause is to protect public funds and provide the appropriate safeguard. So I urge the members on both sides of this House to support this bill and to vote in favor of this bill. Thank you.
Recognizing the minister.
Thank you, Chair. So I will not be supporting the amendment, and I will lay out the reasons for that. So the primary one is because clause in 8 and 9 work together, they need to be consistent in their wording and language. So that's the first reason. And then we'll go over the amendments that the member suggested related to costs. I want to just reiterate that this is about cooperation with our government procurement entities and us all working together towards procuring things in a way that supports the economy during this destabilizing time. And what that means is that we want the government procurement entities to work with us. We want them to feel supported through that work. And we think that's a really important policy objective related to this work. So the members' amendments, for a few reasons, I don't support. One of them is party-to-party costs. The estimate that is about 30 to 40% of the costs incurred by an individual in legal proceedings. So 30 to 40%, I would say, is not a fair partnership or a fair indemnity for our government reporting entities or procurement entities during this time. And I do not agree with the removing of expenses. We went through in detail when these time periods would come in and how they work together with Clause 8 with respect to legal proceedings and how they would eventually transfer to the province. So the number of expenses and costs are already in check in that way. And I think it's frankly unfair to say to parties that we're indemnifying that none of your expenses and we're only going to pay party-to-party costs at a 30 to 40% rate. And it goes against the intent and policy of what we were hoping to achieve by creating cooperation and alignment in what is a really important time to have that cooperation and alignment related to the attack of the tariffs on our economy. And I just want to say the addition of gross negligence. I went into detail before about what the law says about that and why I don't support the inclusion of it. I'll just note that another confusion that it adds to the legal interpretation of that provision is that there may be incidences where negligence, in fact, is bad faith. So by qualifying only specifically gross negligence as something that's named in the statute, the member is in that way creating further confusion about what bad faith means and what it couldn't mean, when in fact it could be a lower standard that meets the threshold of it being included in the definition bad faith at negligence itself. So for many reasons, the amendments don't take away from the purpose, substance, and drive of this legislation, and I won't be supporting them.
Recognize the member for Kelowna Mission.
Thank you, Madam Chair. I remain unsatisfied with the efforts taken to quantify and mitigate risk exposure, and I see this amendment, particularly the amendment to subsection 1, as helping to mitigate that risk. Therefore, I will be supporting it.
Seeing no further questions, the question is the amendment to Clause 9. Shall the amendment pass? Nay. Division has been called. Before putting the question, I remind all members that only the members of Section C or their duly appointed substitutes are authorized to vote. The question is the amendment to Clause 9. Those in favor, please rise or otherwise indicate. Thank you, members. Please be seated. Those voting nay, please rise or otherwise indicate. Thank you, members. You may be seated. Clerk?
Those voting yea, Maas, McCall, Neufeld, Dew, Cooner, 5. Those voting nay, Sharma, Anderson, Chow, Davidson, Krieger, Routledge, Botterill, 7.
The motion is, the amendment is defeated. Recognizing the minister.
I move that the committee rise, report progress, and ask leave to sit again.
Is leave granted? Aye.
Do you have an amendment for
Those opposed?
Okay, those opposed? No. Okay, leave is granted. This, no, I haven't asked for a motion yet. Can I have a motion for adjournment? Aye.
So moved.
So moved. This motion, the committee stands adjourned. Thank you, members.